ಸರಿ ಆಯ್ತು. May I move one matter?
Submission, my lord.
Yes. Application file.
My lordship.
Oh, come here. Come here.
Your lordship, in the suo moto matter. Your lordship.
Yes, everyone who has come from this side to this side, come here. Yes. In the pending matter, final affidavit. Sure. Objection removed. In the urgency. Yet to be filed. Take weeks.
Submission, my lord. I had filed a writ petition against the government, my lord, seeking restatement of my appointment, my lord. This honorable court has ordered my application, but this state government has not considered my.
Have you filed?
I have filed contempt petition, my lord.
It's a fresh contempt.
Fresh.
Lordship, in the suo moto PIL matter, I want to file the impleading written submission on behalf of impleading applicant number 6, ma'am.
Who is that?
Sivakar Shetty. No, impleading applicant, intervener.
What have you filed?
Written submission on behalf.
Not like this. No, written submissions on behalf of.
Impleading applicant.
This one.
MB Nargun, sir, senior MB Nargun.
Is the respondent number 6?
Impleading applicant number 6.
File it in the registry.
My lord, so
Okay.
But so file that no,
Mr. Oda, please.
please.
my lord, so
Sir.
my lord, so this is a commercial appeal of the year.
Take, go.
My lord, this is a commercial appeal of the year 2022. My lord, so last week your lordship had suggested I file an IA for early hearing. I have filed the IA for early hearing, my lord. So,
Be listed.
short date may be given, my lord, as per your lordship.
My lords,
Sir, only 25, sir.
Next quote, next quote.
this is a fresh matter. There's urgency in the.
Petition, appeal,
My lords, it's a writ petition pertaining to grant of minor minerals, quarrying of minor minerals. My lords, similar matter, the respondents are granting the very same land for which the petitioner had applied for grant of quarrying lease. My lords, they had rejected his claim for.
pass. So, with third party.
No, my lords. Third-party rights are being created on this land, my lords. That's this urgency. Kindly have it tomorrow.
You have removed the objections?
Yes, my lords. All objections are compliant.
Yes, ma'am.
My lord, it's a fresh contempt. It's a family matter, my lord. The accused mother has not been complying with the visitation order passed by this honorable court.
The commercial appeal for admission, your lord. Execution is listed on 11/7.
You are the On 30th, I have filed wakalat.
It's a fresh writ appeal, my lords. Office objections have been removed. May I request? My lords, 4.5 crores of money that I have deposited in the non-lien account, my lords. I'm not even the borrower. As a gesture, I deposited that. OTS has apparently failed. My lords, the request for return of the money, direction to return the money has been rejected, my lords. 4.5 crores of my money. I'm not even the borrower. The bank has. My lords, it's a case where the auction was challenged. No, my lords, I am not the borrower. I am not the borrower, my lords. I am not even the guarantor. I am a third party who stepped in. I stepped in. I preferred a writ petition. The issue was not on jurisdiction, my lord. The issue was on merits. Can I request for any time next week?
My lord, it's a fresh contempt, civil contempt, my lord. The subject.
My lord, threat of dispossession, my lord. Without approaching the deputy commissioner, the transmission line, a private company, my lord, private licensees, my lord, on my dwelling house and land, my lord, they are installing a transmission tower. Today, my lord, the police have come and stood in my property, and my lord, I'm moving this matter for threat of dispossession. Otherwise, my lord, fresh writ appeal, my lord. Learned single judge, my lord, relies on yet another order where there was no threat of disposition, or there was no, it was an academic issue, my lord, whether the transmission line can be laid on these lines or not. That order is relied upon by the learned single judge, my lord, and after reserving, sorry, my lord, it was dismissed in October 2024, my lord. It was reserved for, my lord, 90 days, and then, my lord, the order is released. The order is of October 2024. It was released in December 2024, after 3 months, my lord. And even that order, my lord, clearly says you should take permission from the deputy commissioner before approaching the landowners. No, he has not taken deputy commissioner's approval and trampling on my land, my lord. He is installing a transmission tower on my land. Yes, he is in the police station. I have not received anything, my lord. Sorry. No, my lord. It will be an appeal because, my lord, the procedure has not been followed. Even the order, no, my lord. Not in the order that is impugned, my lord, but in yet another proceedings, they approached a separate writ petition was filed. Subsequently, just to say, allow me to bypass the order, bypass the process of deputy commissioner process, and allow me a police protection. Sorry, my lord. That writ petition, my lord, was disposed of on the account that the procedure will be followed. I am not a party to that. I tried impleading myself there also, my lord. I failed. Grateful, my lord. 2:30. No, my lord. 2:30. Today, the police is standing on my doorstep. Grateful.
My lords, it's a fresh.
Union of India, my lord, and the private respondents. Yes,
My lords, it's a fresh labor court compensation matter, my lords. Labor court has awarded the compensation, my lords. Then subsequently, they had filed a writ petition. My respondent filed a writ petition. Writ petition has been dismissed, my lords. Now we had filed a writ appeal, my lords. Already in 2007. Yes, please.
Your lordship, IA was filed in a writ appeal, disposed writ appeal for condonation of delay of 1 day. This Honorable High Court had disposed the writ appeal, directing the appellant to approach the tribunal within a stipulated time. But there is a 1 day delay in filing the appeal, and the Honorable Sustat has directed to get. I filed IA for condonation of delay and recall.
Yes.
My lords, writ appeal, my lords, on the single bench order has been questioned before this honorable court, my lords. The interim protection granted by the single bench, my lords, is going to be end by this week, my lords. The interim protection granted to the petitioner, my lords, is going to be lapsed, my lords, by end of this week.
Yes. The writ petitioners have filed the PIL
against the government for mining department, as they are doing the mining extraction. For that licenses, against that they have filed. The petitioners are the villagers, wherein by fresh petition, but it may connected matters are posted on 14. It may be posted on 14. 14/7. 14/7.
Objections removed?
Yes, yes, madam.
My lords, kindly, my lords.
May I, my lords?
Commercial.
Fresh contempt petition, my lords. Through to 2024 matter, my lords. Not even listed for a single time, my lords. This is I think this is the sixth memo I am moving, my lords.
When did you earlier move it?
A month back, my lords.
What date? And what is the number?
The exact date I don't remember, my lords.
You should, before you make any submission, you should be clear on facts. Any date you have mentioned before this court, any memo, date given.
Before.
If you do not have it without a date, we will say to you.
Your lordship directed the registry to check it, my lords. The date was not fixed.
Okay, then when did you mention it?
A month back, my lords. I
Tell you the date, we put it everything here.
Please, my lords. I'll.
My lords, kindly.
Now take the date.
I'll confirm
Take
that.
the date today.
Please.
Contempt.
Contempt, fresh matter, my lords. 2024 matter. Please.
My lords, kind leave, my lords. Yes.
Yes, sir. 10, sir.
Yes.
That's fresh commercial appeal, my lords. Fresh commercial appeal, my lords. The commercial court, my lords, has returned the plaint on the premise that the defendant number 1 was a club. My lords, yesterday it was, I shall remove it today, my lords. The urgency is this, my lords. My lords, the urgency is this, my lords, that the court has fixed a date today for presenting the returned plaint before the appropriate court. It has returned the plaint saying that a club is not a commercial entity and it does not have any commercial activity. My lords. Yes, my lords. Yes, my lords. Yes, my lords.
Objections and then mention it to this.
May I mention it at 1:30, my lords?
Mention it at 2:30.
Indeed. Great. Great.
My lord, fresh contempt petition, my lord.
Fresh contempt petition.
Kind permission, fresh contempt, my lords.
Fresh contempt.
Objections have been cleared, my lords.
Yes. Serial number 43. Is the complaint with the who is the other side? So you want to withdraw this? What is your good name? Arvind. And Arvind states that the order has been complied with. He wishes to withdraw the contempt.
With my lordship's leave minutes. The same as 64 minutes.
Which number?
Seal number 64.
64.
Yes.
My lord could kindly recollect, my lord, in this matter, sexual abuse of the baby children were pointed out, my lord. Report is there. Then and there is an earlier order of this honorable court to list the matter in the conference hall. Then your lordship said, my lord, it will be taken up at 4 o'clock in the conference hall. But in the
That's right.
Does the order doesn't say so? Huh? No, we also say so. I don't have any such. No, Acha, we noted this order. We,
Just orally, it's we need to remind you.
what is the date of this? Tuesday. We'll have it at 4 o'clock.
Today minutes.
Yes.
Please,
Because
I'll
we
come.
refer to that order of 12th of February 21.
Your lordship is right, Minister.
So we'll have it at 4 o'clock.
Yes, I'll come, Minister.
Okay. Who's yes.
Please.
61. Yes, what do you say? What do you want? Who is the other side?
I appear for the
No objection?
date may be fixed by the mood and execution.
At the request of counsel for the appellant, adjourn, which is for adjournment, which is not opposed, adjourn to.
Execution has been filed, my date may kindly be fixed. Short date, 2 days.
Ma'am, just give a date, ma'am. We give you a date. Pardon? Yes. What, you have filed your wakalat? For R1? What is your good name? NG Sridhar. Just say that the name of the counsel for the respondent be corrected as NG Sridhar. Okay?
My lord,
In
65
the cause
and
list.
65.1, my lord.
Yes.
30th 7, sir.
I'm engaging senior counsel, my lord. Time may be given.
65.1.
65 and 65.1. Both.
Okay. Who is the other side?
Other side, I have.
At the request of counsel for the respondent? No.
Date may be given.
You are for whom?
I am for 65, I am respondent, my lord. 65.1, I am.
For the respondent P. Raghuram. Re-notify on.
Date may be given.
21/8.
Obliged.
Lord,
Serial number 49, my lord. Happy for the petitioners. The respondent has moved the court for this. They filed a new IA. As per the orders of this court, we
appear for whom?
I appear for the petitioners, my lord.
And
My lord, I appear for the opposite. Learned Advocate General is appearing for respondent 5 BMRCL. Kindly, I request this honorable court to take up this matter today.
No, my lord. They had served a copy of this IA on us on the 24th. This is a.
Let him come. Let him come. They have an objection. We'll look into it. Okay. Next.
Serial number 78, my lord, appearing for the respondent
Obliged,
number 4. Kindly have this matter on Monday, my lord. I have informed the other side, my lord.
28.
78, my lord.
Pardon?
78.
Yes. What do you want?
Kindly have this matter on Monday, my lord. Inform the other side.
Just say at the request of the counsel for the appellant, stating that she has informed the other side, adjourn to.
Lord, serial number 58.
28/8.
Yes, ma'am.
Serial number 58, my lords. I appear for the appellant, my lords. Request for 2 weeks' time, my lords. We have sought for certain instructions.
You are for the appellant? Who
Yes,
is the
my lords.
respondent?
Mr. Sachin B.S., my lords. I have informed him, my lords.
Huh?
I have informed Mr. Sachin B.S.
At the request of the counsel for the appellant, stating that she has informed the opposite counsel, adjourn to.
29/8.
Grateful, my lords.
My lords,
Next, call the list.
My lord, serial number 37, my lord. I'm for the appellants. Senior counsel engaged to argue the matter has some personal inconvenience, my lord. I've informed the other side.
Who is the other side?
I'm for the respondent.
Which one?
37.
I have no objection, my lord.
At the request of counsel for the appellant, on the ground of personal difficulty of the senior counsel, adjourn to.
20th August.
Lordship's kind permission, serial number 14, my lord. Petitioner's counsel, PC Sunita. 14. Petitioner's counsel, PC Sunita is not well, my lord.
Who is the other side?
She is the government, my lord. She has not come to the
Who
court.
is the counsel?
PC Sunita, my lord,
They have
petitioner,
been informed that Ms. PC.
government advocate appear. I appear for the,
PC Sunita is unwell.
yes.
PC Sunita, counsel for the petitioner is unwell. Accordingly, re-notify on.
2 weeks, my lord.
2-9,
Next, call the list.
serial number 1, Shridevaya. Number 1,
For the appellant in this matter, my lord.
For the caveat respondent, my lord.
Week's time, I will comply with the office objections.
3 weeks are granted to
A week
remove
would
the
be
office
sufficient,
objections.
because they filed execution petitions. A week's time, may I request, my lord?
It would not be done then.
I will ensure that it is done. As a matter of fact,
We will say so 1 week, otherwise dismiss.
3 weeks time. I will.
Huh?
I have 3 weeks time.
What is the date? Should be that way reasonably. Yes.
3 weeks.
3 week for removing objections.
Grateful.
Date, ma'am.
7-8,
Great.
serial number 2, Shri Pratik.
And that's 1 week's time.
1 week to remove office objection. Grateful.
4-8, serial number 3, serial number 3.
Objection may be kindly overruled, my lord. The office objection is so innocuous. The wakalat says G. Huliappa, the complainant, and he has signed. The office objection says below the signature his name is not mentioned in capital letters.
Just show us that, ma'am.
Kindly see the. I've said G. Huliappa, the complainant, do hereby appoint P.B. Raju advocate.
But there is a original photographs to be filed. That's the objection. In the second set.
I filed it in the first set.
He says second set. And they are right on that.
That is the only office objection as per the system. my lord.
Pardon? The better would be you file it.
And what-
There is a lot of difference in the photographs. Because this is original, that's not. A week's time is granted to remove office objection.
4-8, serial number 4, Shri Subramanya Bhatt.
Appear for the counsel for respondent. my lord.
Yes, Mr. Bhagwat.
But these appeals are liable to dismiss. They are not complied with the office objection.
Pardon?
Office objections are not complied in any appeal.
Yes, Mr. Bhatt.
Lord, as far as my writ appeal is concerned, my lord, I have complied with all the office objections, including payment of deficit court fee.
4 office objection, Mr. Bhatt.
Yes, my lord. My lord, one office objection, my lord, pertains to non-furnished, non-filing acknowledgement for having served the counsel for the first respondent.
1 to 7.
I shall do it today itself. And as far as the other 3 office objections are concerned, my lord, I have filed separate applications seeking dispensation of certain documents. So that application will meet the other office objections. my lord.
What about the 4.1579? Just say that we will give you 2 weeks for every counsel.
Now,
See, without the objections in the other appeal gets cleared, we can't hear the first one.
No, even in the first appeal, you want to dispense
He
with
has some justification, Mr. Bhagwat.
statement of objection, my lord, required to be produced. my lord. That he says.
Just
dispense.
say that 2 weeks are granted to the counsel for the appellants to remove the office objections. Now tell us on service.
My lords, I appear for the corporation, my lords. I've received the
Which
appeal
matter, ma'am?
papers.
In all the matters?
All the matters, my
And
lords.
just show us the file.
I have not yet filed wakalat, my lords. I undertake to file wakalat.
For which? For whom?
For Karnataka Power Corporation, respondent 1 in all the matters.
So you'll file it.
My lords, I've received papers only in 1 from the appellants. The remaining may be served.
Just say that the appeal paper books be given to the counsel appearing for respondent number 1 in all the appeals. Liberty is on the counsel for the respondent number 1 to file wakalat before the next date of hearing. Okay, just have it after 3
No,
weeks.
notice is yet to be served of the other respondents. May not have issued it.
Let notice be issued for the answer for service on unserved respondents.
My lord, may I just, my lord, notice is already issued. Some of these respondents have not been served, my lord. So time may be granted so that in the meanwhile.
Because we are saying, Mr. Bhatt,
Yes.
whoever answered, you serve them. Okay? You noted
The
that.
process fee is not paid to issue notice. My lord has last
That
occasion
is
issued
our-
notice.
I do not
Kindly
know,
see the
Lord,
order
why-
sheet.
It's implied, Mr. Bhagwat, they need to deposit it. They will do it.
My lord, can I persuade this, my lord? My lord, now, my lord, we are in the imminent threat of, my lord, reversion, because, my lord, there is a direction to revise the seniority, my lord, from 1987 after 30 years.
When was the judgment passed?
My lord, this judgment was passed, my lord, on
December 24.
That is, my lord, 4th of December 2024.
Now, we are 6 months away from the date of judgment. Any action taken?
My lord, now everything, all steps are being taken to issue revised seniority list. My lord, as a matter of fact, my lord, this writ petition has been allowed. My lord, taking note of another order passed in another batch of
What
writ
are your
petition.
instructions
My lords, we-
on the revision of the seniority?
my lords, we're in the process of revising the same, but I'll
How
have
long
to
that
seek.
would take?
My lords,
How long the process take?
Court said 6 months to comply it.
I'll have to seek instruction on the exact status as of this date. my
Now, what
lords.
is the stage, Mr. Bhagwat?
Page, my lord, they are yet to prepare, my lord, they have not even started,
Are you sure?
not even started.
She says that it's in the process.
Process only, my lord knows.
Process means started.
But seniority is to be prepared, objection should be called for, then my lord
The
finalization.
process is huge. It's lengthy
Yes, my
process.
lord, court itself said
What
6
are
months.
your instructions, Mr.
My
Bharat?
lord, our instructions are that, my lord, now revised seniority list, my lord, is underway. It is
That's
being
right.
issued.
For how long that would take?
My lord, that, I mean, my lord, it has to be, my lord, informed
My
by
lords,
the
I'll seek
KPC.
instructions, it may be posted next week, my lords. I'll seek instructions on the
My lord.
timeline of.
But interim order is concerned, court said, don't disturb them, kindly see my lord order. But how they could seek such interim order, I don't know.
Which order, Mr.
Kindly see page, my lord, 88, para 21. In writ appeal, my lord,
611.
See, you should carry out all these things, objections, Mr. Bhatt. So that at least we can go ahead with this.
my lord, kindly see the order, my lord. What they say is, my lord, elevation scheme are not disturbed. My lord, they can't say, my lord, they have a threat of reversion.
My lord,
How could they can say, my lord?
we are not the beneficiaries of elevation scheme. My lord,
They are
we
all
we
beneficiaries
are
of
the
the-
beneficiaries of
There are two-
appointment by transfer.
My lord,
You tell us by what time you are taking this complete.
My lord,
complete
your
the
lordship may
process.
be kind enough to have next week, my lord, by which time we will be able to remove all the office objections.
Very well. Just say that, we'll tell you. Call on 14th July.
Grateful.
As far as 4.2 is concerned, we have served on all that.
We have passed a common order in all the three appeals.
14.
Yes, Mr. Bhagwat,
that day my calendar is busy, some other day, my lord.
15th,
15th.
15th.
Yes, in the meanwhile, my lord, KPT cell matter is also being heard in the other court, which it is part heard, but that will have some bearing, my lord, as far as this.
We
is
say
concerned.
nothing, Mr. Bhatt.
Very well.
We will see as and when we take up.
Very
Sir,
well.
KPTC is different, this is different. There are two schemes here.
We say nothing.
My lord certainly will understand quickly this matter, I'm sure.
Next.
Number 5,
It's for appellant.
Mali Patil.
Yes, I may be
I appear for
permitted.
the respondent.
What has happened, my lords? I have challenged the order, my lords. 24 in writ
Are there any
petition.
connected matters today?
Please, my lords, those are disposed, my lords. Those are allowed, my lords. State has preferred the
state has
appeal, my
No,
lords.
against the same impugned order.
Same impugned order, my lords. State has
What
filed.
remains in this?
It may be disposed of in the same
What do you
terms,
say?
my lords. Produce the order copy,
My
my
lord,
lords.
I appear for respondent number 11, my lord.
Lord, an SLP
By
is
order dated,
not wrong. The state had filed an appeal, Dharwad bench had held in favor of the state. I understand there is an SLP that has been filed in the matter. my lord. This is covered matter by this Dharwad bench judgment. Same issue was involved.
No, but this is by this court,
Please, my lord.
by the Honorable the Chief Justice.
The Dharwad bench had also taken a view. Against that order, my lord, SLP has
Harvard
been.
has also followed this, but did
My
you
lord,
check?
the Dharwad bench decision was on 21st March 24, my lord.
Ah,
That has been referred in the.
so what will happen now? This will follow.
Please, my lord. I ask against the Dharwad bench
Have you
decision.
filed the appeal?
My lord, that was state appeal, my lord. We have succeeded.
Oh, yes. Now whether they have gone.
Please, my lord. As
What
far
about,
as,
no, but in any case, this is state appeal. This was state appeal.
Please.
even
Now, the
Dharwad
medical-
bench was state appeal, my lord.
Medical college would not make any difference. It will also follow the same.
Yes, yes.
Who are the appearing for the respondents?
My lord, I appear for respondent number 11, my lord.
No, have they been served, ma'am? Just check up that, huh?
Yes, I was on caveat, my lord. I have been served.
Then you comply with the office objections, please.
My lords, it's a
And we have to-
translation copy, my lords. We had filed the IA for dispensation.
It's up to you. How many are there?
Only one office objection.
No, office objection, how many documents are there in Kannada?
There are quite few.
Quite a few. Then you file your objections, be clear within 3 weeks. Just take this back. Just give it back.
30th July.
Please.
Serial number 6.
Appearing for the appellant, my lord. My lord, I pray 2 weeks time to comply all the office objections.
Yeah, we'll give you 4 weeks
Much,
to comply office objection.
much of
11/8. 7. Serial number 7.
Yes, Mr. Kamath.
Lord, this this dealt with the Gulbarga Fort. Lord, there's a long history. Lord, in the past there have been lengthy orders. The issue is that there are about 282 families which have been illegally living inside the fort. It's a large area.
I know.
Lord,
The archaeological survey stand.
yeah, the stand is that indeed there is encroachment. There are 282 families.
And what is the
And
stand
there was may I take your lordship to a paragraph in the order dated. Lord, that would throw the correct light. Order dated 6/1/2025.
But now it appears the person, petitioner is appearing in person. Just show us.
Yes, my lords.
And, previously,
The-
I think she was represented by counsel.
Hilva.
So it must
Look-
be your case also, they need to be evicted from there.
Yes, and no, there are detailed orders passed long before on that. Would your lordship for now have a look at the order dated 6/1/2025?
Yes.
In this para 8, before a further stern action could be pursued by the court, the following directions are issued. 1, respondents 2 and 3 shall survey the fort area to find out the names of the present occupants, their houses, and the nature of the use of the property which have been constructed by way of encroachment. 2, respondent number 2, the regional commissioner Kalburgi shall file his personal affidavit to clearly point out as to what prevented the said authority from complying with and obeying the directions in the order dated 8/11/2019. Now, please mark the date. It was in 2019. The affidavit shall specifically explain as to why the compliance report is not filed. At the same time, respondent number 2 and 3 shall submit before the court on oath the roadmap and the mechanism which may be implemented by the authorities.
Mr. Kamath, yes, ma'am.
My lord, just yesterday we have received a government order, my lord, where a layout has been sanctioned, my lord, for shifting of these people from the Gulbarga fort to this layout.
So how long that would take?
My lord, we just received it yesterday.
How long would take? Ma'am, layout is, it's a big process.
My lord, exactly for that reason, my lord may have this after 10 days. I'll file an English translation.
Who is the officer who should come to the court?
No, Lord, we've had some difficulties, my lord. It is not that, my lord, we were delaying. My lord may have this after 10 days. I'll place the entire, my lord, case before my lord.
Who is the officer, ma'am? That history is there. We have those forts are history. And you have seen the photograph. These are alarming. I mean, we must say so.
Lord,
Really alarming.
Lord, could I just have 10 days time because I just.
We will give you 2 weeks. We'll give you 20 days. But tell us the officer who is coming.
My lord, that I'll have to seek instruction.
We will tell then who is the officer, under which department it comes.
My lord, it's a revenue. My lord may grant me some
We'll
time,
call
my
the
lord.
finance secretary.
Pardon me, my lord.
Call the finance secretary. This is something clearing something which is so serious.
My lord, as a last chance, my lord, 10 days.
The regional, is a deputy commissioner or the regional commissioner?
My lord,
Main cost.
Who is regional commissioner? What is this hierarchy in the,
my lord, he is higher in.
about deputy commissioner?
Yes, yes.
The regional commissioner of which?
My lord, my lord, my lord, my lord.
You don't understand, ma'am. Let's have the benefit of interacting with him. That's all. We should have the benefit of interacting with him.
My lord, then my lord, I'll just seek instructions. My lord may have this at 2:30.
2:30.
In fact, the regional commissioner has filed an affidavit, but it's a little sketchy in the sense, doesn't clearly lay down the roadmap for the future.
Right.
Serial number 8. Serial number 8.
My lords, in serial
Yes.
number 8, my lords, Mr. Prince Isaac, who is representing for petitioner, my lord, he has been appointed as an additional government advocate. Therefore, my lords, his name may be deleted from the cast list, and my name may be shown in the cast list, my lord.
What is the name of the council?
Mr. Prince Isaac has been appointed as an additional government advocate. Therefore,
Okay.
he is
What
therefore
is
he is
your good
disabled.
name?
Girisha TR, my lords.
Mr.
Girisha TR.
Ma'am, has he filed the wakalat?
My signature is also there in the wakalat, my lord.
Just check up that. Just say that we have been informed that Mr. Prince Isaac has been appointed as a government advocate. That be so, the name of Mr. Isaac be deleted from the cause list, and the name of Mr. Girisha TR, who has also signed wakalat on behalf of the petitioner, be reflected in the cause list. Be reflected. Yes. Just say that re-notify.
$28,800.
Please, madam.
Serial number 9.
My lord, may I seek leave of this court? I'm a party in person. My advocate is not well. May it please your lordship, there's a premium FAR concept has been introduced by the state of government.
Premium?
FAR. And for which I have filed a public interest litigation to challenging this legislative intent. Because since it is concerned to the planning, urban development and equitable compensation to the land acquisition, and as well as the constitutional guarantees under Article 14 and 15. So, my lord, we have filed application in
amendment. Just show us.
Yes. When the act has the amendment to the act has been implemented and the rules also has been framed, which we have challenged in the year 2022. And subsequently, the matter is all got admitted by issuing rule and in the year 2022. And in the year 2025, they framed a regulation pursuant to the amendment, which we have challenged. And there is a.
Do you have any objection on the amendments?
So mainly state government.
for BBMP.
Tell us, ma'am.
Not my exam in 2 weeks' time, sir.
Pardon? Okay.
Because it's the,
Just
then
for
the
the last
notifications that are sought to be challenged.
You have made a prayer on those for those amendments.
Yes, yes, my lord. I have filed IA and seeking for amendment.
So and so appears for the respondents, seeks and are allowed how much time?
2 weeks to file reply to the amendment application. To the application whereby the petitioner has sought amendment to the writ petition.
My lord, till the time, I may request that let the issuance of a premium FR certificate could be stopped till the time.
Yes, consider it, let the reply come.
My lord, only thing is the same undertaking is already taken in other writ petition by the same petitioner.
Undertaking to what extent?
Not to issue the premium.
All right,
FR,
that will hold the field here also.
but till the next date of hearing. So that's
Not, no, is there any some other petition pending?
yes,
Where there is an undertaking given, they will not give effect to?
yes. They told us up to the next date of hearing they will not
So
issue.
that will be binding in everyone. That is binding on the state also. Once states is not bringing it, it's good, no requirement.
Much of
Next.
21-8. Serial number 10, Shri Hari Prasad.
Appearing for the complaint, my lord. Some office objection raised, my lord, by the.
Just say, ma'am, additionally, copies of the application, if not served, be served on the council for the respondents. Okay. Then say reply.
My lord, in this matter, my lord.
And for accused number 1, my lords. Accused number, it seems that accused number A4 to A5 have filed memo of
Have not
retirement.
rectified the objection, my lord. Then the second thing, my lord, accused 2 to 5 approached me and they are telling to compromise the matter and handing over the key. For that, their advocate is not appeared. That's why they have issued the notice, everything, my lord. Acknowledgement is not yet come. That is why.
You appear for whom?
I have here only for accused number 1, my lords.
Who appears for the others?
That's what, my lords, they have, let me complete, sir, please. Accused number 2 to 5, my lords, they have filed an IA for termination of their wakalat, which is rejected by the office. And memo of retirement had to be filed. That's what the objections is
So
there.
you appear for one,
Accused number 1 only, my lords.
the bank, the
The bank.
officer of the bank.
Yes.
What about the 2, 3, 4, 5?
Their advocate had filed on IA for terminating his wakalat as against accused number 2 to 5, which has been rejected by the office.
If that is allowed, my lord, it will be compromised because accused 2 to 5 approached and told me that while serving the copy, they will hand over the key. If it is key handed over, then it will be closed.
Fresh notice may be issued to accused number A2 to A5.
If you call next week, my lord,
Then why don't you ask them to appear in the court?
I will ask my short date may be given. I will ask them to appear and it will be closed.
Just say this.
Say that we are ready to hand over the keys, etc.
Yes, I will call and they will file a compliance memo.
You may say that you will not press the petition against accused 2 to 5.
No, it will be before the court only, my lord. They will, I will call them and next week it may be posted within 2 or 3 days.
Just say this, so and so is present for respondent number 1. Respondents 2 to 5 are not present. We find that then application has been filed. That's only on, application has been filed only by A5.
A5 on behalf of the 2 to.
On behalf of A2 to 4. A2 to 5. Full stop. Appropriate shall be that their presence be secured for the next date of hearing. You inform them.
I will inform. Short date may be given, my lord. It will be settled.
Have it after 2 or 3 weeks, ma'am.
1-8. Serial number 11. 11, Shri Sadashivappa.
Yes, tell us, Mr.
My lords, the learned single judge has directed us to execute a reconveyance deed in favor of the complainant, my lords. We went near the property, my lords, for which reconveyance has been sought. We found that, my lords, the property is in possession of a third party. And, my lords, we sought clarification from them and documents as to how they are in possession, my lords.
From them?
No, my lords.
From the third party?
From a third party. And, my lords, once we made an inquiry with them, they have gone ahead and filed a civil suit, my lords, for bail injunction against the BDA, claiming that, my lords, they claim title independent of the BDA as well as the complainant. And their first document of title is dated back to the year 1957. My acquisition is in the year 1959. Subsequent to 1957, there has been the property has been conveyed twice before it has went with that particular third party. Now, my lord, the civil suit is pending before the Honorable Civil Court. Of course, my lords, there is no injunction that has been granted. Bare injunction suit based on possession has been sought, but also in the paragraph they say that they are in uninterrupted possession for a very long time. Under these circumstances, my lord, I am yet to execute a reconveyance deed in favor of the.
Did you bring it to the notice of the court concerned? This order passed by this court?
The learned single judge, my lords, we have not done it, my lords. We were, my lords, we have not done it.
Are they party there?
They are not party there, my lords.
What do you think? What do you say? You will seek your impleadment, or?
I only invite my lord's attention to the order of the learned single judge, where they have said we cannot execute sale deed, but we execute the reconveyance deed. It is their statement. Kindly see page 9, paragraph 2.
No, but suppose a third party is claiming a right.
My lord?
A third party is claiming a right in the property.
My lord, how could they? It is acquired land.
We don't know.
One thing is, they have not put anything in writing before this honorable court, which they sought time last time.
You're right.
If they put it, my lord, then I can say something.
Give me a copy.
We have given him a copy.
You file it in the registry.
Please, my lords. Please.
Sri Lanka counsel for the respondent states that the reply affidavit shall be filed in the registry during the course of the day. A copy thereof has been given to the counsel for the petitioner, who may file a response within 2 weeks.
I'm sorry, my lords, may I make the submission? That's what I have submitted, given to them as a copy is, my lords, a memo with the documents. For the affidavit, my request your lordships to permit me until tomorrow, my lords. I'll file it tomorrow.
You will file your affidavit. No memo. Is it a memo?
It's a memo, my lords, the plaint and the objections. I'll file an affidavit tomorrow, my request for tomorrow, my lords.
Yeah, just give it back. Give it back. You will file a reply affidavit and then bring it on record. Then a counsel for the respondent seeks and is allowed a week's time to file reply affidavit. Response thereto be filed within 1 week thereafter. Re-notify on.
30th/7.
Because they cannot come up with a new story in the contempt proceedings, my lord, when they have admitted.
Yeah, you will say so in your response.
Yes, please, oblige, my lords.
Next.
12. Dakshata Shetty.
My lord, for appellant, my lord. I have filed
Yes,
the
ma'am.
application for restoration of writ appeal, my lord. There is a delay. The application is ready. The office objection is regarding filing of application for condonation of delay, my lord. May I file it, my lord?
This was dismissed. Re-entry order. You have filed the application.
Yes, restoration application is filed. Delay application, I am filing it now. It is
You
ready.
have filed it? No. Are you filing it?
Filing it, my lord.
We say just at the request of counsel for the appellant adjourn to. You file it in the meantime.
Yes, my lord. Date may be kindly given me.
Give the date. Ma'am, do one thing. Your writ appeal has 11 objections.
That need to be complied when.
Very well. Additionally, liberty is also granted to the counsel for the appellant to remove the office objections in the appeal.
Grateful, my lord.
14/8.
Any date, my lord?
14/8.
14/8. Great.
Serial number 13, Shri Girish. 13.
None for the petitioner adjourn to.
10/9.
Ma'am, just do one thing. Let notice be issued to for respondent returnable. Notice to respondent.
10/9. 14 adjourned. 14 adjourned. 15.
My lords, from 15 to serial number 21, we have filed writ appeals, my lords.
You have filed?
Writ appeals, my lords, already filed, my lords.
From 15 to?
21, my lords.
May I please, my lord. Writ appeal on 3/3/2025.
They have the
it is
details
filed,
as such, I'll pass on the same.
And till date, my lord, it is under the stage of complaints, my lord. Even it is not complete the.
You tell us
We
when
will
are you getting
endeavor
this?
to get it filed within 4 weeks.
No,
as
the
such.
writ appeals will come here only.
Very much.
These are 24 matters.
25
25.
matters, my lords. 2025, my lords.
Now you tell us by which day you will get your appeals listed on this day when we are listing contempt?
Any date after 4 weeks, my lordships may give it.
I take 4 weeks, Mr. Chandrasekhar.
3 weeks, my lords. It's a batch of appeals, English
3 weeks?
translations, my lords.
Just say that Mr. Chandrasekhar states that writ appeals have been filed in all the contempt petitions of which non-compliance is alleged. He states that he shall ensure the appeals are listed on the date when these contempt petitions are listed. Just have it after 3 weeks.
My lords.
31-7.
So 31-7, you will expected these appeals will be listed.
Lord, serial number 15 to 21, same matters.
That's right. We have passed a common order.
Yes. Great.
22.
Yes, Mr. Chandrasekhar.
This is the compliance affidavit filed. There's a rejoinder filed, my lords. This is the return of the original sale deed executed in favor of the complainant. In compliance affidavit, it was stated that it's been returned, but the real fact is it's not been returned and it's missing in the sub-register office, my lords.
Who is the officer who signed it?
The officer is also present before the honorable court, my lords. So the averment in the,
Let's see that memo.
my lords.
What does he say?
In the affidavit, they said, madam, they complied. For that, I filed a counter affidavit. Actually, that is not the original sale deed. It's a scanned copy on different papers. I request let them file affidavit at least, whether what happened to that original.
Para 3 at page 2, my lords, of the compliance affidavit dated 13th of January 2025, my lords.
You say page 3.
Page 2 of the compliance affidavit, para 3, my lords.
So 8/1/25 released.
But it's factually not correct, my lords. It's not the original of the sale deed.
Where are the officers here? Have they vanished?
My lords, on advice, I told this compliance affidavit cannot sustain. So I ensured a police complaint is filed with regard to the sub-register coming forward and stating that the original of the sale deed has been lost as such.
Then on what basis does he say so?
My lords?
On what basis does he say so release?
On 13th of what's been stated can't stand justification before the honorable court. So he had to come out with the actual facts. As a first step towards the same, before I could file a further compliance report, telling the actual facts, I've ensured that 1st of July 2025, there's a police complaint made with regard to the loss of the said sale deed, my lords.
So what was given to them?
What was given is like now it's the digitization era, my lords. So the downloaded scanned copy was attested and given to them, my lords.
It was scanned.
My lords, already the copy which is scanned will be in the software as such. So one original copy always stays in the sub-register office. That needed to be given to the complainant herein. Because it was not there, they should have come forward and stated the same as early as 13th of January 2025 itself. They have just made a printout of the same, certified that as the original and given to the complainant, my lords. Certified that as the true copy and given to the complainant.
So what is the way out?
Your 11E sketch has created this problem.
My lords?
Sorry, misrepresented them.
11E sketch, he has created this problem. Isn't it?
It was a prerequisite for release of the said document, my lords. Agricultural properties, 11E sketch. Now the dispute is pending before the Honorable Supreme Court. This court held the view that 11E sketch is not compulsorily mandated, but the Supreme Court has stayed this Honorable Court's judgment as such. So post the stay of the honorable, post the stay obtained at the state SLP by the honorable Supreme Court, we reintroduce the necessity of producing the Lebanese sketch, my lord.
You have reintroduced, now you have to answer this.
The answer as a first step is I have told him to come fair, and I have told that
See,
How does this get
see,
lost?
he could not have retained that document. If a sale deed is produced for registration, you are ready to take the stamp duty, but you are not ready to register it. If 11E sketch is not accompanying the sale deed, why did you retain that? The original should have been returned.
no, they should have
Your
not.
office is not safe. Your office is not safe.
The document was subjected to release subject to the production of Lebanese gun. As my lordship supposed it, our office is not safe. That's the reason this mischief has happened as such, my lords.
But tell us one thing, how a sale deed gets
Disappears.
disappears? This is serious.
They gave the sale deed. It didn't contain the 11E sketch, that is survey sketch of the fiber cage. They sold one portion of the land. For that, the survey sketch, they call it as 11E. No, that didn't. Therefore, once they did it, they kept that deed in the office.
You should have returned it.
You should have returned that. And after.
No, it was kept pending for registration, my lord.
Affidavit tax, please. Affidavit tax.
My lords, we did speak to the complainant, my lords, bringing out the actual facts, and if a fresh affidavit is filed, they are satisfied, my lords. That's the input.
Fresh affidavit for?
Fresh affidavit telling that what's been given.
Here are in good terms.
Yeah.
Seller and the buyer are in good terms.
No, my lord, because that is the problem, my lord. That's why I'm insisting. At least I must say in the affidavit, because the civil suit they filed, I have to prove that sale deed by signatures. This scanned sketch, I can't prove that sale deed, man. That's my difficult. I'm expressing my learner friend. If suppose they could have come with the true facts, filing affidavit is lost, therefore issuing, so that I can place a civil court and request that. Instead of that, my lord, they played a fraud on the court by saying that we release the document. That's why I filed a counter affidavit by producing the sale deed, and the accused has not filed affidavit. That is the problem.
So what is the way out?
My lords, the first reason for us to file a fresh affidavit.
File it.
We'll file the fresh affidavit, my lords. The first step was to register the true facts. We'll state the
They say
same, my lords.
Mr. Chandrasekhar states that though an affidavit dated 13/1/25 is filed, comma, he intends to file.
Government education, because I am also Chandrasekhar, he is also Chandrasekhar.
Mr. Naveen Chandrasekhar.
Government education.
Mr. Naveen Chandrasekhar.
On instructions, my lords.
On instructions. He states that, say though an affidavit has been, compliance affidavit has been filed on 13/1/25.
Permission to withdraw the said affidavit may be given.
As there are certain factual mistakes in the said affidavit, he intends to withdraw the same. We will keep it, withdraw the same and file a fresh affidavit.
Let the accused, let them file, madam. Someone has filed affidavit.
Appropriate should be that fresh affidavit be filed. The fresh affidavit be filed within how much time?
A short date may be given, my lords, as it's fresh in my lord's memory.
The plea of withdrawing the affidavit shall be considered on the next date of hearing. We will see what is the discrepancy.
My lords.
Twenty-eight-7. Serial number 23, Shri B.L. Sanjeev.
Lord, in these cases, my lord,
matter has
we
come
had
up
to
sixth
comply,
time.
certain applications have to be
The
made.
time
my
for
lord.
office objection.
For Kannada, we have made an application, my lord, for dispensation, the Kannada translation, my lord. My lord could exempt it, my lord, it may be called for. The other things, my lord, we will.
These are
Sixth
connected
time.
matters, no? How many are there?
25, serial number 25.
23, 24, 25, 26.
Malats, only 25, Malats.
Who? You appear.
I appear for R1, respondent 1.
My lord, both of us have challenged the said order, my lord.
Same
The
order.
impugned order has been challenged by BDA as well as the society, my lord. All these matters, my lord, your lordship may fix a date, my lord.
What are the numbers? 23, 24, 25,
26, yes, ma'am.
31 and 33 also.
33 is also.
31 and
33.
and any other matters?
Other
And-
three matters are there.
Just take that.
My lord, I'll also give list, my lord. I've got three other matters. I'll produce it. Even 51 is connected to with this.
Now, what about 32?
32 is different.
Different. It's a different matter.
I think 51 is also connected. 51 is, my lord, the party in person.
51?
It is also connected with this man.
Contempt of court petition.
So we take it 23, 24, 25, 26, 31, 33, 51.
Another one is, which is missing in this today's list is WA 4246. It is already dismissed for non-compliance of office
Then
objections.
whosoever is, who appears for them?
He appears for them.
So file an application. So 51, these are the matters. Just say that re-notify these appeals. And also, appeal number 31, appeal number 31, 33 and 51. 26 is number.
And another
On.
another
Give a
three
date,
matters.
Which are the other three?
I'll just give it now, my lord. 2 minutes.
No, you file a memo for them.
I'll do that. My lord.
Those are also 24 matters.
All the same common order, my lord.
24, you file a memo for them.
Oblige.
My lord, it is a contempt of court petition. Our order was passed in March actually. And
You
they have not
filed
complied
a
with it.
contempt.
Huh?
Serial number
Filed a
51.
contempt.
Yes, yes, my lord.
That
That
only
is
has come up today. my lord.
51.
Huh?
51, serial number 1081 of 2024.
51 is a contempt.
Yes,
Yeah, my lord, yes.
Contempt as against the order which we have challenged, my lord. All that.
No, we got it. No, we want to know. Ma'am, 51.
Order passed in the year 2024.
You will
It's
say
been
just
1 year.
re-notify. 51 should be a separate order, re-notify on the same date. And so appeals being 23, 24, 25, 26, 31 and 33. Re-notify. Contempt also re-notify on the same. Okay. Full stop. It just say that in item 51, this contempt petition be listed along with writ appeal number 1244 and of 24 and connected matters. In item 51.
In these matters,
Pardon?
may I make a small submission, my lord?
Yes.
Request in these cases, in that all these cases are relating to allottees of the society who have been sites of society, who have been deprived of the sites as well as their money. And taking into account the directions given by the division bench of this honorable court earlier, the learned single judge just passed an order saying that they have to pay compensation to us as per the market value. There is a deliberate violation of the orders passed by the honorable division bench of this honorable court, both by BDA as well as the society, wherein they were directed to remove the encroachments and hand over a possession of the sites to the allottees. That has not been done. And in taking into account all these factors, Leonard Single Judge has rightly awarded the compensation. It is not something, Milord, which is without any this one. My respectful submission, let these matters be heard immediately, Milord.
31, 31, 33, 51. 51. 44 of 24. Along with 26 of Pinmar Corner. Even more separate order, along with writ appeals. Along with numbers 1246 and 19 cases.
The sites are not available. They say you give compensation.
The earlier order of the division bench is there 2010, my lord. Huh? Site ಇಲ್ದಿದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ಆದ್ರೂ ಕೊಡ್ಬೇಕು ಅಂತ ಅದಕ್ಕೆ ಸರ್ ದಟ್ಸ್ ವಾಟ್ ಮಿಲರ್ ಇವರು ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಇಸ್ ದೇ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ದಿ ಸೈಟ್ಸ್ ಲೆಫ್ಟ್ ಅಂಡ್ ರೈಟ್ ಮಿಲರ್ ವಾಟ್ ವರ್ ಅಲಾಟೆಡ್ ಟು ಅಸ್ ಅಂಡ್ ಆಲ್ ದಟ್ they taking into account all those factors ಮಿಲರ್ the red single has passed there.
In the writ appeal.
Hearing about this society.
Yes, my lord. Your lordship has heard these matters, my lord. In one of the matters, your lordship has disposed also.
Okay, give the date.
In earlier date if possible, my lord.
Okay, give the time, give date now.
A shorter date, my lord. Some
19.
date in the near future.
19/8.
Next.
My lord, 19th, by the granddaughter's naming ceremony is there.
31, 33.
My lord.
It's a contempt. We will tell you in 51, you say that.
14th.
List this contempt item with petition number 1, 2, 3, 4 and connected.
September, October.
That's what you have to say in item 51. And these matters, as 19 say, as these 19 either from a common order, they are being tagged together. Okay.
Short accommodation, my lord.
Short accommodation.
They have given a most shortest accommodation.
Is one more month.
Next.
Already.
Please.
Next.
So much delayed. My lord, one more submission I want to make before this. One, I have a sales deed here wherein 3 sites are allotted to saved person and executed is sale deed. The actual value of these 3 sites together is 6,600 square feet. It is because of that we have not given sites. It is there. I submitted to the court also. Please give a shorter date, my lord. We are all senior citizens.
Next.
Serial number 27. Shri Mushtaq Ahmed. 27.
Complainant. Appear for complainant.
Yes.
The accused person is failed to comply the order of the single bench. Direction is to deposit the amount from the date of the order passed by the assistant commissioner, my lord. From the filing date of the petition, my lord.
These are the 3 respondent need to deposit.
No, only respondent number here, accused to be deposited, my lord.
And I filed the objection along with the annexure.
How was the direction given?
My lord.
What was the direction?
My lord, direction given to the respondent hearing to deposit the rent whatever he collected. My lord, there is no basis to deposit the rent because almost all rents have been received by him has been spent to his father.
Where in the order of which contempt is alleged?
Other than that, my lord, The petition, complainant herein is under sir.
Date of orders, my lord, annex,
Connection, D, my lord.
page number 60, my lord, para 9.
Yes.
The respondent number. Accused here, my lord.
So tell us,
My lord, in,
did you challenge this order?
yes, my lord.
Did you challenge in a higher forum?
No, no, my lord.
So this order stands against.
No, my lord. In para 9 of the orders, you not make kindly permit me to read. Respondent number 3, who is admittedly collecting rent from suit item, item number 2. Item number 2, I am not collecting, my lord.
You don't know.
Because this order has not been rectified or amended.
No, this is a final.
Yes, my lord. I do agree with it. Item number 2 is different property. Item number 1, my lord, that is the property where.
The oversight, it is mentioned, instead of mentioning item number 1, my lord, it is mentioned item number 2.
1 minute.
Right or wrongly, he is collecting the rents from the scheduled property, he has to deposit.
Yes, tell us.
It is,
This gentleman, call him.
the orders passed in September, my lord.
My lord, I have filed objections.
Till
along
today, he
with
is
the
collecting,
document.
even after the order also, he has not paid the rents, my lord.
Let me
Even
say,
after order also, my lord.
What do you say? What is the stand in your compliance affidavit?
my lord, my father and my other brother availed a loan out of the item number 1 property. Wherein, my lord, I have paid 22 lakhs 33,000 13 rupees to the said loan account. And as well as, my lord, to my father. Whatever the rent collected by me, my lord, I have paid the same to my father.
Ask him to be appear before the court on the next day.
Yes, my lord.
Let him be present and let him be, we are just only putting it to you.
Please, my lord.
Very well, with this defense, we will not take it. Getting the point?
Yes, my lord.
One submission, my lord.
To come prepared.
One submission, my lord. One submission,
Then, my lord,
I am a senior citizen. I am permitted to collect the rents, my lord, at least from today itself. Let him pay balance amount. I have to survive, my lord. I am a,
It's a fresh gain for you. You can't do it in a contempt.
my lord, I would like to.
You have heard the counsel for the parties. Prima facie, you have the view that the respondent has not complied with the
My lord,
non-compliance.
before that, my lord, I would like to take my lordship to page number 30 of my set of objections. Annexure R5, A5. Wherein, my lord, the very complainant during pendency of
what is
the
the page number,
WP. My lord, he has executed an illegal gift deed in favor of one Nivedita, the last daughter. He has not, my lord, he has not disclosed before the dishonorable court.
Just say this, having heard the learned counsel, just say, having heard the learned counsel for the parties, we direct the presence of the respondent, B. Raj.
Yes.
B. Raju, for the court on the next date of hearing, after 10 days.
In the meanwhile, my lord, kindly consider page number 30, annexure R5. He has no locus standi to file this CCC because he has already, my lord,
This direction given, why was this direction given by the court? Yes. Are you still owning this property?
property already again gifted when stay was there
It is in
before
the
this honorable court.
he is collecting the rents, my lord. I acquired the same.
How would you say that you are entitled to the rent?
My lord, he is
I
seeking
acquired the
rent
land
from
the
my
partition.
under sister and from me also. He's-
Ask him to be present.
Date may fix, my lord.
Ask him to be present in the court.
Yes, ma'am.
16/7,
Madam?
16/7, sir.
Okay.
Narway.
Much.
28, number 28.
Complaint in this case. Give fresh address steps manner. Give fresh address manner. Victim will take fresh address manner.
Should this, their fresh notice be issued to respondent number one? On the council furnishing the fresh evidence.
Please, manner.
10/9, 29, serial number 29.
Chablis.
Serial number 29.
For appellant, my lord.
49, serial number 30.
My lords, respond number 3 notice to be maybe dispensed, my lords, because of the reason the respond number 3 comes under the appellant institute. I is a medical superintendent, my lords, that may be dispensed, my lords. And the other connected matters have been directed to be listed on 8/9, my lords, with respect to this. There are other connected matters, my lords. My lords, furnish that, because the lordships has granted on 8/9.
1284.
Today also they are listed.
Yes, my lords, there is a delay. And even, my lords,
8 and 9. They say that we notify 28/8. 28.
69, 70, 71. my lords.
8th of September.
Please, my lords. And there are another 3 matters, my lords, which have been listed for preliminary hearing, 69, 70, and 71. In those matters, my lords, notice has to be ordered, my lords.
So you want dispense with R3.
Please, my lords, in this matter, my lords.
At the risk of the appellant.
Please,
So you notice to respond to the 3 days.
please, my lords. And 69, 70, 71, notice has to be ordered.
Which are the other matters?
69, 70, and 71, my lords.
That we have adjourned.
No, sir. it is there.
No.
69, 70, 71. Who appears in those matters?
My lords, notice has not yet been ordered, my lord.
Will come then. Who only appear in those?
Please, my lords, I appear in all the 3 matters, my lords.
Are the objections cleared in 69, 70?
Please, my lords, I have cleared, my lords. All the objections have been cleared, my lords. They have listed for preliminary hearing.
Yes, there is 69, 70, 71.
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಸರ್. ಇದ್ರಲ್ಲ 3ರಲ್ಲೂ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಸರ್.
71 issue notice.
Please.
Issue notice to the Mr. Shikha,
Notes, 4th respond notes in 30.
in 4.
Please.
1 and 2, my lord. 1 and 2.
8, 8, 9.
And you will say this As the appeals have been filed challenging the common.
Please. Please,
8, 9.
please, much.
Thirty-two.
Appearing for appellant, my lord. Prays for 2 weeks time to comply all of his obligations.
But 34 is also not connected, arising out of the same order. Similar order may be passed. Thirty-four. I appear for the appellants.
This is also same.
Arising out of same order, my lord.
Notice to the unsubscribed respondent.
Please.
And the office objection fee to both need to both pay.
Please.
15, 9.
Please.
Thirty-three adjourned. 35. 35, Shri P. N. Rajeshwar.
For the respondent to, the case has settled, the advocate has not come. Out of the court, we have settled the issues.
They say not for the appellant as well.
Three cases. 35. He has come.
I appear for respondent number 1.
Settle ಆಗಿದೆ. Memo sign ಮಾಡಿಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. On 695. Nine five.
There are three
Three
writ
cases.
appeals. 3 writ appeals.
1691, 1.
Service will notice be issued to the unserved respondent in 1727 and 169.
Nine, 9.
Obliged.
36. Seal number 36.
But at least for the respondent, there was a direction for me to produce the drawings. So the drawings are ready, Lord, I'll have to collate and Lord, file those. Lord may grant me 2 days time.
I have the copies of all the drawings which is available in this file pertaining to this 26. As if I were to recollect.
No, Lord, I am made to give to them. Yes, all the drawings, Lord.
Lords,
And
I have
should
requested,
be-
Lords, that
I-
let there be an order that there should be no precipitative action pertaining to this property because these were the properties where my residential constructions were in place. Lords, now they demolished and as a result of which I came before the learned single judge. Now, my lords, the property is vacant. Let it be kept vacant. The BDA will
It
My
is
lords, the-
kept vacant. I have the photograph to show that it is fenced and the board of the BDA is put up. Lord, what has happened is, Lord, kindly see, he claims a right over 20 guntas of the land. He has sold 26 guntas of the land in this very same particular property. Come before the court and say, my property is demolished. I shall place all those documents, which.
Lords,
This
all
is-
the more
Lord, I am
reason,
yet to
Lords,
file.
if
I am
this
yet
is
to-
what they
I am
want
yet
to
to file.
contend, all the
No,
more
I am
reason
not-
the matters to go before the learned single judge.
No,
The
no,
reason
no,
is
no.
this. On the first hearing date, I just want to say this. Matter is moved at 10:30, the matter is taken up at 2:30. The learned single judge says that without looking into the, because if the statement which is made by the learned counsel appearing for the BDA is true, all the more reason the matter is to go back because the learned single judge does not refer to any of the submissions which is said to have been made by the counsel appearing for the BDA. The learned single judge only says that having gone through the contents of the writ petition, I am of the view that there is a disputed question of fact. Notice the disputed question will come only if they file the statement of objections or if there was anything stated and recorded by the learned single judge saying that these are the questions which would be in the nature of disputed questions of fact. Lordships.
Lakshmi, grant me 2 days time. By Monday, I'll file. I'm filing the sketches, Lord, and the Google Maps from 2014, 16 up to present. Lord, I have the sale deed, Lord, one of the, yes. Yeah, I shall
No.
make it a part of record.
Now it has to be produced.
No, that
it
was
was not.
suppressed. That was suppressed. A fraudulent sketch was produced.
It is.
That-
No, it
No,
was
it
not.
was shown to the learned single judge. I'll show it, Lord.
My lords,
Those
it
two
was,
sketches.
I am under instructions. I have taken instructions from the counsel who appeared before the learned single judge. No statement was made with reference to the sale deeds, which they are now making.
Lord,
It's a false statement.
No, Lord, I don't make false statements.
It is a false statement. I can vouch for it.
I am ready to file an affidavit.
That the sale deeds were
Lord, I
mentioned
am
before the
ready to
learned
file
single
an
judge.
affidavit
Let him
if
file
it
an
is
affidavit.
said, if the statement is made against me, I am ready to file an
Yes,
affidavit.
he has to. Now the time has come
I
that
am
he has
ready.
to be filing an affidavit.
No. You file
Yes,
an
yes.
affidavit that this was done. Under whose instruction it is being made submission, I know it.
The drawings as were shown to the learned single judge. When the order was passed, but during the hearing, when the impute order was passed, shall be filed by giving a copy to the learned counsel for the appellant in 2 days. Just give it on Monday or Tuesday.
Lordships.
8-7,
Obliged.
37 adjourned. 38, Shri Vishwanath.
In this, my lord, there was a specific direction to the acquiring authority, my lord, to specify with regard to the extent of land that is going to be acquired in my survey number. And also give the particulars of extent of land that is going to be acquired in my survey number, that is survey number 19/2. My submission, my lord, survey number 19/2 is in existence since 1927-28, my lord. The father of the petitioner was granted 4 acres of land in survey number 19/2 way back in the year 27-28. My lord, they issue a notification pertaining to survey number 19 showing the extent as 2 acres, 15 guntas, 15 quarter guntas, my lord. I filed a writ petition. I gave a representation to specify what is the extent of my survey number that is going to be acquired, what are the trees that are going to be acquired, what is the compensation I am entitled for. They did not respond. I filed a writ petition, my lord. This honorable court was pleased to direct them to specify with regard to my representation. Again, my lord, they come up with the same contention. Your lordship may kindly peruse page 33 of the counter affidavit, my lord. Totally, my lord, it's misleading. I will not be in a position to get the compensation at all. Para 7 in page 33, my lord.
Where is 6/12/24?
My lord,
Make
in
sure
counter
R1 is the
complaints
endorsement
affidavit,
issued, my lord.
counter, my lord.
6/12/24. Where is it?
May I request your lordship to kindly peruse para 7 of page 33, my lord. And that is a counter complaints affidavit filed by the respondent. Page 33, my lord. It's a petition filed before the reference court, my lord. Once again, they commit the same, your lordship gets it, my lord. Para 7, my lord, page 33. The petitioner further submits before the Honorable Court in respect of survey number 19, total extent of 75.5 acres. Out of this extent, 2 acres 15 quarter guntas has been acquired and 4 crores 98 lakhs and odd has been compensation was fixed and award orders obtained. But in this 15 guntas acres acquired, 5 members have constructed building and they are residing in the unauthorized buildings. So here, my lord, my submission is that, my lord, I never own any extent in survey number 19, but my name has been shown in survey number 19 as one of the owners. But again, my lord, they come and try to dispossess me as far as my extent is concerned. It is a specified survey number since more than 1 century, my lord. 27, 28, the separate existence for my survey number is there. On several occasions, my lord, the road was formed on my survey number. 19.2 was the survey number mentioned in the said award notices. Even RTC extra shows the survey number as 19/2, showing the larger extent of survey number 19 and showing my name and trying to dispossess me was uncalled for. That's why, my lord, I filed a writ petition seeking a direction to specify what is the extent of land that is going to be acquired in my survey number. That was directed to be considered. Without considering this, again they proceed on the same basis, my lord. That's where I am aggrieved. That is, my lord, annexure C I have in page 19 is there, my lord. That was annexure R in the writ petition, my lord. Here I have annexed it as annexure C. Your lordship gets at page 19, my lord, of the contempt petition. May I read?
Kindly see page 22. The substantive relief what they have sought is to drop the acquisition, my lords.
That was one inter-alia, that one of the prayers, my lord. But they proceeded. The award was passed. But
Page
at least they should specify what is
Roman
the
4, my lords. Survey number 19 within bracket, survey number 19/2.
that is 75
So
acres.
they get a 1 paragraph order from the writ court telling this is to be considered and endorsement is to be passed. We have done the same. There's a detailed compliance affidavit also filed before this honorable court.
My lord,
Annexure R1 dated
my
2nd
grievance
of
is that,
December
my lord, survey number
2024
is
the
75
endorsement
acres
issue.
owned by
We have
several.
deposited 4 crores 98 lakhs before the city court, my lords.
My lord, my submission is that, my lord, I don't intend to challenge the award, my lord. Let them specify what is the extent of land that is going to be. Yes, my lord, yes, my lord. But in the meanwhile, let them not take precipitative action, my lord. I'll challenge, because the issue is this, my lord, having come to know that I am the owner of survey number 19/2, again and again, my lord, pursuing the same notification in respect of survey number 19 and trying to dispossess me is totally illegal, my lord, in spite of a direction.
Annexure R1 at page 12 of the compliance affidavit, my lords. That's the translated copy, my lords.
So you have to challenge this one.
Very much, my lords.
That's there, my lord, but the
My lords, I have also verified on the factual aspects. 19/2 became to 19. Simpliciter in 2019, my lords.
How can
Hereupon
you
the records reflected survey number 19. We have specified 2 acres 15 guntas. If my lord sees the endorsement, 2 acres 15 guntas and 1/4 acre in survey number 19 was standing in the name of their father. With regard to the total extent, because there is an issue with regard to the ownership, that is the father has demised, now he has 2 legal heirs, 4 crores 98 lakhs have been deposited before the reference court also. ma'am.
Inter se, we have no dispute as far as legal heirs
Now
are
there's a
concerned,
road
my lord,
project which needs to be implemented, my lords. Only because of the pendency of the contempt petition, we are unable to go forward, my lords.
My lord, my
The wo-
submission. My lord, but in the meanwhile, what my submission is this, my lord, my entitlement.
They can do it. 19, whether it was 19/2 or 19, whether that change has taken place, that's what they say.
I am not a, yes, my lord.
Now, inquisition, if they are also ready to give the compensation, that has been amount is deposited.
Yeah, that's where, my lord, I am aggrieved. The survey
They are
number
also
19
parties as
is owned by
respondents
so
before
many
the reference
people.
court, my lords.
When they are not specifying with regard to my entitlement, what is the extent that we let them undertake to specify with regard to that, my lord, I have no grievance. Allah, that will not happen,
That's
my
the
lord. When
reason,
once
let
road
the
is
reference
formed, I
court
will- the
adjudicate.
identity-
You have made them as party respondents, my lords.
Allah, identity of the land will be lost, my lord, when once they complete the road, unless they specify it.
My lords, there is a issue with
Which of these survey numbers it is passing through, you have a sketch, give it them.
Yes, let them give the sketch and show what is the extent that is going to be lost by my.
You are not agreed by the acquisition.
Yeah, no, my lord, I am not agreed. I have not challenged the and compensation. Wherein, my lord, if that no, the issue is this, my lord. Survey number 19 measures 75 acres.
Para 8 of the
There are
complaints
so many-
affidavit for a movement.
There
my
are
lords.
more than 60.
That reaches 75 acres. In that, you are inquisitioning to.
Yes, my lord.
Kindly take para 8 of the.
Tomorrow, if I go there, my lord, I will not in a position to produce any records pertaining to survey
May I
number
make
19.
the submission?
So I will be
Para 8
nowhere.
of our complaints affidavit may be kindly seen, my lords.
Again, they adhere to survey number 19, my lord. Page 5.
We have.
Mine is 19/2, my lord. It has its existence since 1 century.
We have
How can
stated.
they say that it is?
You also add on the land acquisition also order officer is also not clear.
My lords, we have stated.
Page 13 of the order which we have passed. See the second line from the bottom. Page 13.
13 of the
13 of the compliance affidavit.
compliance affidavit.
Survey number 19, bracket 19/2. What does he mean by this?
Earlier it was 19/2, my lords. It got reclassified at 19. In the endorsement also, they have referred to the same, my lords.
That can't
In
be-
their very own endorsement given to us.
Yes, my lord. Let that be, in the meanwhile, let them not precipitate. They- My lord, my lord, what happens, my lord? Again, if the identity of the land is lost, my lord, once again they go on contending that it's some part of survey. Where do I get the documents to show that I am the owner of survey number 19? If I go before the officers to get the award amount, my lord, even a landowner will not get the compensation. When once my name is not there, there, my lord, they say that, my lord, the landowners have not produced the documents. That is the, yes, my lord, in page 33, that's what I wanted to say, my lord.
Lords, para 8, 9th line for a movement, my lords. May I read out for a movement, my lords? From the 9th line of para 8 of our compliance
For
affidavit
depositing of, sorry,
at page 5, my lords. Page 5, para 8. My lords, I'll just go through the entire para. I state that pursuant to the said award notice dated such and such, the respective landowners failed to produce the necessary relevant documents pertaining to the rights and ownership of the respective lands, including the petitioner. Further, when the authorities intended to deposit the said award amount before the jurisdictional court, they learned that the father of the petitioner, late C.S. Kalyan Nayak, had demised on 5/2/2022 as stated above. Hence, the petitioner, along with his brother, has been made as a party in the LAC proceedings as claimants. I further state that the compensation amount is deposited on 11/7/2023 in LAC proceedings before the jurisdictional Ramnagara District Court in LAC such and such, where the petitioner along with his brother are arrayed as claimant number 8 and 10 respectively to claim their compensation to an extent of 1 acre, 2.5 guntas. We have detailed out why we have made them as a parties as such. This compliance affidavit will also come to their aid, my lords. We have told that certain extent of land was standing in the name of their father. When we ourselves verified, as the father had demised, we have made the legal heirs as parties before the reference court.
My lord, they are not coming forward, my lord, because it runs for 75 acres. Specifically, when the road comes to my extent, my lord, what is the extent they are, they let them rather specify it, my lord. I am satisfied with that. My lord, they say that it is in respect of survey number 19. Again, if they say, that's where, my lord, I am not in a position to produce the documents pertaining to survey number 19 because I hold the all revenue documents in.
According to you, 19/2.
Yes, my lord. 27, 28, I have produced. That is 4 acres, my lord. My Kalyan Nayak was granted 4 acres of land in the year 1927, my lord. Continuous revenue entries are there in respect of survey number 19/2. In 19/2. No, my lord, that's where your lordship may kindly peruse the documents which I have produced along with the writ petition. It is clear that, my lord, from 1927 itself, my lord, the existence of survey number.
Present survey number 19.
Survey number 19/2 is there, my lord.
That I'll clarify, my lord. That I have to clarify on the revenue side and get back, my lord. From my understanding of the.
19/2 is there. Then you simply saying that 19 you find out your litigation.
No, they themselves say survey number 19 within brackets 19/2. Now the reading of the compliance affidavit says out of 4 acres, 1 acre, 2.5 guntas, my lords. My lords. My lords, two things.
19/2 cannot become 19. You're getting the fraction.
I got the fraction.
19 would become 19/2. It's not the reverse. If
Yeah.
that be so, then, so what is, according to him, it is 19, then 19/2. That's how it should flow. Then how would you justify it? You are saying that it is originally 19/2, now converted to 19. How can that be?
I'll clarify on the said issue, my lords. I'll clarify on 2 issues, my lords. Whether 19/2, what's the original extent standing in the name of his father? I'll get it, my lords. I'll get it.
Yes.
They say they request Mr. to take the instructions.
28/7. Serial number 39.
Serial number 39. Appear for the appellant's matter, your lords. I'll take necessary steps.
11/9. Serial number 40.
Appear for the complaining. Here for the accused, my lord. In fact, it's a batch of writ petition, your honor. The complaints affidavits are ready, and your lordship in the few more contempt petitions have listed the matter to be brought on 7/8, your honor. If this matter is also called on 7/8, a common compliance affidavit will be filed. Great. Maybe another 15 days because it's gone for the board's approval here. Yes, deeply obliged. Well, in advance, I just serve a copy on you. Deeply obliged.
41. Serial number 41, Shri Shirish Krishna.
My lords, appearing for the appellants, my lords, we have served the copy to the proposed defendant proposed respond number 2, my lords. Here's the copy.
My lords, we have filed a contempt after which the appeal has been filed, my lords. No objections have been filed to our contempt petition still, although 6 months have passed, my lords. They may be directed to file objections to our contempt. Today, my lords,
Today only,
both
my
are
lords.
listed.
My lords, we'll file it on the next date.
I appreciate, my lords. Let them file their
A
objections.
date may be fixed for hearing.
My lords, what
Labor.
they are trying to do through this impleadment application, this is basically, my lords, if I may submit, my lords, this is a case in which under the Building Cess Act, my lords, certain amounts were withheld by KPTCL, my lords, who is the respondent number 1. My lords, only respondent number 1 was before the writ petitioner. Now in the writ appeal, they have brought up this new excuse saying implead the actual state government under the Labor Department because they are the ones who withheld. We've had no communication whatsoever with the Labor Department. There is no cause of action against the Labor Department. Now, just to further delay the matter, they are trying to introduce. We have filed our objections to that impleadment application also. My lords, under the Building and Other Construction Workers Act, my lords, a certain amount is, yes, absolutely, my lords. So my case is that there were 3 independent contracts, one for construction, one for erection and supply. It is settled law that only under construction you have to withhold. Insofar as supply and erection, nothing is to be withheld.
My lords, may I?
They cannot now bring in the Labor Department after 2007 construction sites, my lords.
My lords,
This
we
is
have,
clearly to delay the matter. They can file an appeal, I appreciate. They cannot implead now the Labor Department. I have no cause of action. There's not a single piece of communication between me and the Labor Department, nor have they sought to bring them on record earlier.
my lords,
My lord, it's application with their appeal, my lord. It's an application of impleadment which they have filed.
my lords, the cess which we have got. My lords, the cess which we have paid, that is, we have already paid to the Labor Department. Directly, we have implemented them because they can directly give it to the.
My lords, pursuant to the, absolutely, well, pursuant to any directions of the court, let them, they will pay, they will abide. Why do, now if the Labor Department also has to say their position, we will be further affected, there'll be a delay. My lords, in fact, some of this deduction of cess has been for certain projects which happened prior to the act coming into force.
Let's assume it is found for this project, amount has been paid to the Labor Department.
Please, my lord. Please, my lord.
So you have any objection for Labor Department to come in?
As far as then let them file their objections at the earliest. They haven't even served them. They're not taking
We
any
have
steps.
served them a copy, my lords, of the writ appeal.
They say this is an application. So Chandrasekhar, you would appear that Labor Department.
I would take notice.
They say that this is an application. This is for seeking
We have served a copy. We have served.
State of Karnataka through Labor Department, through Labor Commission. This building, Dr. V.R. Levikadu, as a party responsibility to the Labor Council for the
Appellant.
respondent number 1. What do you say? Shall we say do not really seriously contest the impleadment?
My lords, he's my colleague. My lords,
We are writing it to you. Objections.
we have filed our objections, my lords. We have said that there is no cause of action so far as we are concerned. There is nothing that the Labor Department has to do.
Has filed objections to the application contesting the impleadment, given the fact that it is the case of the appellant here that that after deducting the cess
Cess, my lords.
under the provisions of the
Building and other construction.
provisions of the
Building and other construction workers.
Regulation of Employment and Other Condition of Service Act 1996, the amount has been deposited with the Labor Department. The newly proposed impleaded party. With that being the case, with that being the case, and the stand of the Labor Department must come on record, appropriate shall be that the so-and-so is made a respondent number 2. Which for Mr. V. Chandrasekhar accept notice. Let a copy of the writ appeal be given to Mr. Chandrasekhar.
My lords, it's already served.
Additional copy may be given.
Just give another copy.
A date may be fixed, my lords, for hearing.
Reply affidavit to the appeal. Okay, within 4 weeks. Rejoin, sorry, pending be filed within 4 weeks. See, the directions have been given.
It's already.
Single judge.
Please, my lords.
To the appellant.
Please, my lords. Absolutely.
Yes, my lords.
We had gone to you.
You have to disperse.
Them, or they should pay. That's the point.
Issue of disbursement. Issue of disbursement as such.
Disbursement. See, he has decided the issue of disbursement. He said they should pay. They said we have deposited with you. Then you should pay or they should pay.
My lords, there is one more I for condonation of delay. That may also mean.
My lords, it's date may be fixed for hearing on I number 1 and 4.
In the appeal, my lords.
For the reasons stated in the prayer for seeking condonation of delay, they say in the application is closed.
28/8.
Please, my lords.
An earlier date, my lords, may be fixed. Grateful. Grateful.
42, serial number 42.
This is for the appellant in this case, my lords. My lords, I have taken the process, my lords, I've taken this process on 11/6, my lords. On 11/6, I've taken the steps, my lords.
Just say that the notice to the respondent shall be issued on the process fee set to have been deposited on 11/6.
Please, my lords.
11/6 will be. Just say that let fresh notice be issued.
Please, my lords.
Let fresh notice be issued.
11/9. 43 withdrawn, 44. 44.
Lords, I appear to be complainant in this matter, Lords.
My lords, I filed my wakalat in
On
this
the
matter.
order of 24.
I may be on a short date to file my response to this matter, my lords.
Lords, my application of 13th of August.
How much time?
3 weeks, my lords.
3 weeks.
Response, my lords. Yes, my lords.
48.
Grateful, my lords.
45.
Grateful.
I
beg to appeal for the complainant in this matter, brought.
Lord, I pray for 2 weeks time. For this reason, my lord, we have filed a review petition before the division bench of this honorable court. But bench has not been, this matter was decided by His Lordship Justice Krishna Dikshit. Now, my lord, we have moved a memo before the service bench. My lord, they said move before the registrar. We have placed, moved before the registrar, it is not yet posted, my lord.
Your Lordship may kindly
2 weeks time, I
your
kindly
Lordship may
be
kindly
granted.
peruse page number 21. The orders of this honorable case is on 24th March 2025. The direction was that your Lordship may kindly see that at page number 37. 37, the respondents are directed to continue reinstate the petitioner forthwith as joint director. Review petition, let them do, let them continue my service forthwith. Then what is the purpose of forthwith? I'm working in BBMP. I'm reinstated STR as a joint director of STRRPA. Member secretary of STRRPA.
But in the order, my lord, the division bench of this honorable court, instead of continuation for 2 years, my lord, it is observed as 3 years. For that, we have sought for, my lord, order is at yes, come to page 28. In the last operative portion of the order, in the last para, my lord, consequently, the respondents are directed to continue, reinstate the petitioner forthwith as joint director cum member secretary of SSRPA and permit him to complete for 3 years. But in fact, the complainant herein is a group A employee. 3 years you have to complete, you have to allow him to complete. 2 years is the tenure, my lord, for. How much tenure he has put in already? I'm sure that. But is 1 year, 10 months, man. 1 year, please, my lord, 1 year, 10 months, my lord. 1 year, 10 months? Please. Still there are 2 months time was there. Man. Please state it. So in 2 years, we will see by the time review will be decided. See, that's what we had asked for this information on the last day. Please. Please. I'll take instruction. Maybe a week's time I kindly be granted, my lord. In the meantime, will. The time that review need to be decided. That depends. Will be whether it should be he should be continued for 3 years or 2 years. And mind it, come to page 28. But I'm not served with the copy of petition. 28 says. It says prescribes 3 years term for member planning. Please, ma'am. Here, the complainant herein is a government servant in the capacity of joint direct town planning. Is a group B post. As per the transfer guidelines, my lord, his tenure of office is 2 years for group A employees, my lord.
Both before the tribunal and before this
regarding that,
tribunal,
my lord, we have sought
I
for
made a
review.
specific plea
Regarding that,
regarding
that we have sought for review of that, my lord. Your lordship may kindly grant me 2 weeks time, my lord. We will in the. Please, please.
Then it becomes 2 years.
Please, my lord.
For 2 years, you cannot have the grievance.
Please.
2 years is not yet complete. Then you comply that.
But as of now completed, as of now, my lord, during the course interregnum period of this, my lord, he has completed, my lord, in the month of February itself, my lord.
That also you didn't comply. The contempt remains.
Please, my lord, I will take instructions. 2 weeks time may kindly be granted, my lord.
Mutual understanding, it was 2 years, you should have complied in 2 years. That also you didn't do. Isn't it?
Please, my lord.
And you are finding some of the one reason that you are filing the revision.
Immediately we have filed, my lord, because of, my lord, because of his lordship's transfer, it is held up, my lord. Otherwise, by this time it would have been.
It is different.
Please. I'll take instructions and some.
At least according to you, if it is 2 years, you should have complied that. And then come to court saying that no, it is not 3 years, it is 2 years.
That
The review, there is no stay order,
my lord,
nothing, they are not even complied.
regarding that, my
They are
lord,
not in the office objection has not been
please,
complied
please,
with by them.
please. Regarding
For the
that,
sake
my
of that review petition that is done, let them comply with this order, not subject to the outcome of the review petition. I have no problem. Let them comply with this order. Comply with subject to the outcome of the review petition. Simply they file a review petition, that is pending, that they are not in complaint with the office objection. Please not.
Please, please. I am for A2, my lord. A is A1 is the state, my lord. State has to answer that.
Who has to do it?
A1 has to do it.
Could it be week after next, immediately week after next?
No, my lord, please. What is the purpose of the orders of the 4th week? The order.
My lords, we have to revert back if the stand has to stand, my lords. So within a week's time, it would be a little difficult.
Who has filed the review?
Review, even the state has filed, even the authority has filed. Both reviews are pending, my lords.
Please.
Just say that this on 14th of
Very much.
Please,
my lords.
14 July.
Please, it may be next week, not please, please, the purpose is not, your Lordship may kindly see that this honorable tribunal was pleased to.
Is he retiring before 14 July?
He is not retired.
He will have it on 14 July.
Please.
Enable the counsel for the respondents take instructions.
Please.
46, Shri Mallikarjuna.
And for the appellant, my lords, the officers raised objection stating that the appeal is not maintainable. In fact, the issue is covered by judgment, my lords. A writ appeal is maintainable on an order passed, a final order passed in 227 of Constitution of India, my lords. May I pass on the judgment, my lords?
227.
Yes, my lords. It's covered by judgment, my lords. There's a decision of this own court, my lords, wherein the court has held that the writ appeal is maintainable, my lords. May I take my lords to page number 11, my lords? The flag which I placed, my lords. In fact, my lord, this is also an order passed in file under 227 of Constitution, my lords. May I permit it to read, my lords? As to maintainability of writ court of appeal under so and so. The first submission of was in respect of the intra-court appeal of kind not maintainable, the impugned judgment has been rendered by the single judge in exercise of Article 227 of Constitution of India. Does not much impress us, and reason for this are not far seek. Right of appeal is a creature of statute. A legislature can create such a right even against an act of postman or peon, if it is so chooses. Section 4 of Karnataka High Court Act states so and so, so and so. Next, my lords. Ordinarily, the power exercised by the constitutional courts under 226 is in the nature of original jurisdiction, and therefore, the orders emanating therefrom may be termed as original judgment, order, decree. The expression employed in Section 10, Clause 4A of the 1961 Act. There is no dispute that orders made in exercise of such powers are amenable to challenge in intra-court appeal as provided in Section 4. However, when it comes to an order passed under Article 227, it cannot be gainfully argued that it is a product of exercise of original jurisdiction as such. It has long been settled that the power constitutionally vested under Article 227 is special, limited, and supervisory in nature, and the content wide so and so, so and so. However, that does not mean that the legislature cannot provide an appeal against an order passed under this Article 227(2). A right of appeal is created by the state legislature by enacting Section 4 of 1961 Act mentioned so and so. The scope of this section has to be determined in the context of Section 10 in general clause and 4A of therefore in particular section. They extracted 4A, my lords. My lords, in 4A, my lords, Section 10 4A, there's specific distinction, my lords. 4A, an appeal from any original judgment, order or decree passed by a single judge in exercise of powers conferred under clause 1 of Article 226, comma, Article 227 and Article 227 of Constitution of India. My lords, now just come down to the point, my lords. A plain reading of this clause leaves no manner of doubt as to orders passed inter-alia under Article 227 being appealable regardless of the limited scope of such appeal. The expression original judgment, order, decree employed in 4A of clause 10 of section 1 so and so, which category was highlighted, is confined to orders passed under 226, which indisputably vest original jurisdiction in High Courts as contradistinguished from appellate court, revision or supervised jurisdiction. It is Article 227, comma, in contrast, which vests supervised jurisdiction. However, that does not bar the legislature from making even such orders appealable. If it is so chooses, it's a matter of legislative judgment, and the judiciary, being a coordinate organ of the state, has to show due deference to it, subject to all just exceptions. An argument to the contrary would render clause so and so would defeat the legislative intent.
We just have it some other day. Just say that we notified an issue of maintainability of the appeal raised by the existing, both the learned legal counsel for the respondent. Appellant, which relies upon the judgment of the complete bench of this court, and it being dated 27th August 2024, the 006 of 2020.
My lords, the matter will be disposed of before the trial court, my lords. It's a direction matter, my lords. MC matter where I'm appearing. The direction ends by end of this month, my lords. My lords, it was a petition filed by the husband. I am the respondent wife. I had filed a maintenance under section 24. He is drawing salary of rupees 4 lakhs. A meager sum of 25,000 came to be ordered. My lords, I have sought for 50,000 per month for myself and my child. My lords, I am working as a teacher for 12,000 rupees. Is not disputed. My salary is 12,000. He is working as a president at JP Morgan, my lords, and drawing a salary of rupees 4 lakhs, my lords.
23/7.
My lords, my humble submission is a short. There's a direction matter which may be disposed, many merits disposed of.
47.
Lords, in 47, Lords, I act as the amicus. There is a report by the legal.
Children. In fact, if
Lords.
my lords were to see the last order.
Lord, may I make one submission before the other side starts? As an amicus, last time, my lords, we had the Legal Services Authority had been directed to submit a report on inspection of 51 BBMP schools. Report had come. In fact, my lord, the report does not reflect a very satisfactory state of affairs. The schools run by the BBMP for the poor children, my lords, do not have the proper infrastructure facilities. I think that should be attended first before anything else, my lords.
There was a report to be.
My lord, I appear, my lord, I'm not in the main litigation, my lord, I'm in a side litigation in the sense.
That can take
certain
with
lands
great
were allowed.
respect.
No, this is
My lords,
a
with
totally
great
different
respect,
issue what
the-
Mr.
for-
Nathan is appearing. In fact,
Lords, I would only submit, first your lordship may consider the report of the Legal Services Authority regarding infrastructure facilities of BBMP schools. That assumes importance because toilets, drinking water, nothing is.
Who appears for the state? Now BBMP, who appears?
I appear for BBMP, my lords.
What is your take on the report?
I have not been provided a copy of the report yet.
Legal Services Authority was to prepare the report.
They have done it.
They have done
They
it,
have
but
done
in
it,
fact,
and my information is it's also been sent to BBMP. In fact, last occasion his colleague was there.
Where is the report?
Lords, your lordships will have it like a paper book. It's filed on 11th of June.
See, we will give you a report, but we want your response on that.
Yes, my lords.
Just show us.
Was- If your lordship kindly come to just the summary of it at para 7 in that report.
Yes.
At page 4. At least BPM should respond to it. Para 7, they have given the summary common observations. And
There is
one
a
of
lot
the
of observations made by the.
Yes, Manoj. And one
Legal
school is running right next to a bar. One school is
Pardon?
right. One school is running right next to a bar. Please see L, my lords, in para 7, classitum L. Or
And
clause
Mr.
L.
Phanindra, this is the position in respect to all the BBMP schools?
Yes, most of the schools they have inspected 51 schools pursuant
No,
to the
which is
orders
the
of
other
this.
government authority running the school in Bangalore?
No other authority, my lords. No other
No,
authority. It's only
government schools are also being run?
BB.
not within the limits of BBMP, my lords.
My lords, there are two types of schools which are run in BBMP. Within the territorial jurisdiction of BBMP, there are BBMP schools and there are government schools. For government schools, the government will be the appropriate authority to answer. For the BBMP schools, particularly which comes under the jurisdiction of BBMP, I am told there are about 49 schools for which I had filed my report, on which the court was pleased to direct the LSC to conduct a further report on that. That I am yet to receive a copy. For the other schools, the government will be answerable to that.
Ma'am, what are your instructions? But we don't have a report on government schools.
My lords, if I may interject for a moment, on earlier occasions, it was specifically brought to the notice of this court that the governments, all the schools within limits of BBMP are run only by BBMP. This report pertains only to 51 schools run by BBMP. Government schools are outside the limits.
Let's see these 51 schools run by BBMP.
Yes, my lords. Your lordship may kindly come to the chart, my lords, annexed to the report, which your lordship should get.
That's right.
Please come to page 33, my lords. They have given about each school. Running page 33 has a chart from 33 onwards. Now,
Are they being provided other benefits under the Right to Education Act? The children, the school children?
No, no,
As
in
of-
fact, the basic requirement under RTE Act is that basic infrastructure, what the amicus is stating, basic infrastructure of water, separate toilets, playground, all of that has to be there. And the report, in fact, it was done to ensure that already these were not being complied. The report at page 33 shows there's no water, there's no washroom. My lords, how can children, then they say that children are not coming to school. How can children come to school if
We'll
they're
give you
from?
this report.
Yes.
We'll ask them to give you this report.
I will do that.
And you will file your response within 2 weeks. And you must see
Yes.
there are a lot of observations which have been made.
I'll respond.
And we have now right to education. There are other benefits which must accrue to the children. Let's talk about the infrastructure first, then we can possibly look into those.
Yes.
And if basic infrastructure is not there, my lords, can we even say that children's right to education is fulfilled? And these are under BBMP schools.
And this is basically for the poor downtrodden.
Schools are.
There are many schools. In fact, just.
What is the position beyond Bangalore?
My lords, that
it
their
should
survey
be
was
all over
conducted.
Karnataka.
No,
This,
no, all, my
scope
lords,
of the PI should be all over Karnataka.
Lords.
It is all over Karnataka.
one minute.
In a government school.
My lords, all the schools, about 500 and odd schools all over Karnataka have been surveyed. Reports have been given. Those schools were surveyed in the presence of a representative of the Legal Services Authority.
And
We
That's
found
part
certain-
of this petition, Mr. Fanindra?
Yes,
Yes, yes.
absolutely,
These are
my
all
lords.
found.
Those reports, we have given the status reports.
Just say
And in
this.
fact, the court directed the BBMP schools in Bangalore to be surveyed because Bangalore being the metropolitan city, there is no excuse to say BBMP schools don't have funds for basic infrastructure.
My lords, if I may, my lords, I have one.
I appear, my lord, in two applications that have been filed, my lord. I am, my lord, the Ramakrishna Ashram, which is running, my lord, a school in Mysore. My lord, government granted us some piece of land, and my lord, a portion of that land was occupied by another school. Now, my lord, some residents and also the students filed a series of cases saying this land should not have been granted to the ashram. Those proceedings, my lord, went up to the Honorable Supreme Court, and the Honorable Court, my lord, held that I am entitled to that land, and I have now started the school, and I'm also building a Viveka Smaraka, my lord. That is where Swami Vivekananda stayed for nearly a month before going to Chicago. So, my lord, the building has come up now, and they lost through. They filed a PIL that was also dismissed. Now, my lord, what they do in this proceeding, where this has nothing to do with individual school, mischievously they file one application to say they want to come and intervene in this, and the court, my lord, without making me a party. So, my lord, my submission is this IA, my lord, 1 of 21 which they filed has to be dismissed, my lord, for this reason that they have exhausted all remedies and they cannot, my lord, agitate any of these rights. That is my submission, lord.
Who appears for this 1 of 21?
Somebody
Yes.
online, I think.
Pressing on any, the school has been demolished and it
But
has
you have
been
filed this application 1 of 21.
1 of 21. I filed the application, my lords, only to assist my lord.
What is the prayer? What is the prayer?
My lords, my simple prayers to only assist this honorable court in the public interest litigation, my lord. That's
So
all.
what is the public interest litigation about?
My lords, this is in respect of the infrastructure facilities which are available in these in the school, my lords, and whether the state.
Where is your prayer in the application?
My lords, that is at page number 18, my lords, of the application.
My lords, apologies if I can kindly just be excused.
Yeah.
Apologies.
Just show us that application.
Along with the application, I also filed a note, my lord, raising the issues which are pertinent, my lord. That may also be looked into.
So we take it you want to only assist the court.
Yes, my lords. Yes, my
with
lords.
regard to the prayers made in the petition.
There are no, my lords. There is no prayer as such, my lords.
So much of
I would only want to point out, my lords, that whether material assets of the state in the form of a fully functional government school can be divested for any other purposes, my lords.
Lords,
That
with
is my
great
own-
respect, as an amicus,
We are
I would
only
submit.
Since, my lords, we are only using
That
this
very issue is examined in at
as
least
an
5
example
decisions.
to demonstrate, my lords, to demonstrate how material assets of the state in the form of a fully functional government school is being divested for other purposes. That is all. We are only using it as an example. We are not. We just want to assist this court in respect of infrastructure. In fact, I want to place a report of the CAG, my lords, which has prepared a report in the year 2024 in respect of the infrastructure facilities.
Where is the prayer that has been sought in your application? What is the intent of filing this?
Page number 18, my lords.
Page number 18. Now read that.
My lords, wherefore it is humbly prayed that the Honorable Court may be pleased to permit this applicants to intervene and assist.
For intervention, but for what purpose?
My lords, we just want to place certain aspects on record, my lords. That is it. We
It's
are
all
not.
right. Why do we require an assistance tell us intervention? We will look into this.
My lord,
As
No,
an
it's not
amicus,
allowed.
if I
What
can
I'm
make
saying,
a
my lord,
submission,
is
my lord.
every time, my lord, they raise an issue because it is abuse of the process. That's what I'm submitting. I filed objections, my lord, pointing out and filing copies of series of cases where, my lord, if your lordship should see.
The same applicant, who are the petitioner?
Yeah, same persons, same students. They come for PIL, that is dismissed. They file a petition saying that the school should not have been closed, that is dismissed. They challenge the grant of land to us, that is dismissed. Then they set up, my lord, to go to the child commission, that is dismissed. All of it I have produced.
Yes.
My lords, I
As
request my lords,
an amicus, may I
my
just
lords,
make one sub?
I request my lords to only look into our note of issues, my lords, which is filed on 12/1/2021, my lords. We have raised 5 issues for the consideration of this honorable court, my lords.
See, what is the issue which has been raised in the petition and what is your claim and what is the purpose or what is the intent for you to seek an impeachment?
My lords, exactly the reason why I'm requesting my lords to just refer to that memo note of issues which I have filed on 12/1/2021, my lords. We have raised 5 issues for the consideration of this honorable court.
Why an intervention by you? Who are you?
My lords, we were students. We were students
So,
Students of what?
of the government Maharani NTM school, my lords, which was established in Mysore. My lords, that school has now been shut down and it has been transferred over to another building, my lords. We just wanted to point out as to whether such grants could be made by the state government, whether material assets of the government school could be divested for other purposes. These are the issues we have raised in this intervention.
How are these issues relatable to this PIL?
My lords, the PIL is in respect of right to education, my lords.
That's right.
Whether the government, when the government itself does not have enough infrastructure in government schools, my lords. The issue which my lords is considering is whether there is infrastructure or not. And this was a school which had all the infrastructure, which had a playground, which had the...
Which school you are talking of?
My lord, the government NTM, Maharani NTM government school, which was in Mysore, my lords. Now the school has been demolished and these students have been transferred to another...
That very issue, my lord, I produced along with my IA 1 of 22, my lord. I produced all the judgments. All of them, my lord, this very issue was raised. Whether this land could be given, whether the school, my lord, the school had hardly 20 students. This students, my lord, were accommodated in the new school that is run by us.
Now we take it the issue now sought to be raised is an issue which you have raised on earlier occasion.
My lords, we are not on the issue of whether the government was correct in allotting that land or not, my lords. We are only trying to...
The issue then.
My lords, that is the reason why I am requesting my lords to please refer to our note of issues which we have raised, which has been filed, my lords, on 12/1/2021. It is along with our intervention application. There are 5 issues which we have raised in that.
My lords, sorry for the interruption. As
Yes.
an amicus, my lords, I would only submit these intervention applications may not be necessary. If they have raised the issues, the court and we will consider that, my lord, because this, my
That's
lords,
right. Yeah, you are there, Mr. Farindra, as an amicus.
Yes.
We will obviously it will come through you only.
because otherwise, my lords,
Relatable to Right to Education Act, you will answer.
I will answer that, my lord, because otherwise this is some sort of a getting into in the middle, my lords, of a greater issue.
My lords may please refer to our note, my lord. We have raised pertinent issues. It's not something which is not pertinent to the present issue at hand, my lords. There's a note of issue along with our intervention application. We have raised 5 issues in that.
Where is the note?
My lords, it's along, it has been filed separate, it was handed over in open court, my lords, on 12/1/2021. It is along with our application, my lords. I'm sorry, my lord. My lord may permit me. I will file a fresh copy of the issues, my lords, which we have raised.
See, we have something filed on 25/1/21.
My lord may permit me one opportunity. I will produce this.
Do you have
memo.
that, Mr. Nagan?
No, I also don't have.
Lords,
Then you
I have
file-
the note. I have the note.
Yes.
So I may, with great respect to my learned friend, say the way the note is prepared is exactly what was canvassed in the PL which Mr. Naganand was referring to.
Then you give a copy to Mr. Naganand.
Please,
I'll only furnish it to Mr.
The
Naganand.
copies in the orders of the Honorable Court in PIL I have filed, my lord.
No, this note.
Yes.
I will serve that.
Specific to his intervention application seeking intervention here.
Very well.
Your case is that, given the background, that the attempt is only that.
Exactly.
I'll furnish it to
Yes, we have said so. Yes, Mr. Nagan, Mr. Fanindra?
Well, Lords, I will furnish the copy of the note to.
Yeah, just
my
give a
learned
copy
friend.
to.
Yes.
Just say this. Let a
Your
copy of
Honor, if I may make a submission, I'm party in person. I'm Katyayani Chamraj. The basic petition refers to out-of-school children. And with reference to that, orders about the infrastructure have also been issued by this honorable court. But the main issue is that of creating a database of children at the ward level and the Gram Panchayat level of all children from 0 to 14 years and to keep track to ensure that all of them are going to school. I have filed a memo, Your Honor, on 1st of March for which, and I have been raising the same issues since 1 year, but no response has been coming from the government.
We'll just see, just 1st of March memo. Yeah, just show us that. Ma'am, you have this memo? This is primarily directed against you. You see this memo?
Amicus has also raised the same issues in his last report, Your Honor.
Lords, I have also filed a status report referring to the party in person's report. Memo. The state has to respond to it.
When the intent is only this, you have the database of all children who should be going to school so that you ensure this Right to Education Act is implemented. That's the intent. And that's the duty of the state. Ma'am, where do you say your prayers?
In my memo of 1st of March, Your Honor, 1st of March 2025.
Yeah, paragraph 25. Now, do you have any database where the children born till 14 years or 18 years, whichever is the age period, for during which they are entitled to the education as a matter of right? The intent is only that, so that everyone gets it. Every child gets it till he attains the age of 14 or 18. That's the intent. Do you have any database on this? You file a response to this.
We have asked this, even I have recommended that the state files a response, my lords, but the state has data which is known as SATS data. It's all there, my lords. They should update it periodically, including government schools and private schools. They have on
They have to
software.
update that data or correlate that data with the school database.
Yes, that's, my lords, I'm told it is done on real-time basis. Almost the digital data is maintained. Only thing they have to have periodical meetings and other things to discuss about how to bring back the leftover children or these children who go out of schools.
If you correlate, suppose those children who are left out, they can also come in.
Your Honor, they are supposed to carry out a household survey every year, 1 month before the school starts. And based on those figures, the attendance authority has been designated, the education coordinator. He has to issue notices to all the parents whose children are eligible to come to the school. And if the child does not come to school within 7 days of the school reopening, that process, the protocol has to be in place where he goes back to the parents and asks why the child is not coming. And in spite of his persuasion, if they do not send the child to school within the next 3 days, the child and the parents have to be brought before the child welfare committee. And the child welfare committee has to provide whatever assistance the parents need in order to send the child to school. And in spite of giving the assistance, if they don't send the child to school within a time frame, the time frames have been fixed in the circulars, the child welfare committee has to take charge of the child and place it in a residential school. So that is the main purpose of this petition, Your Honor, to ensure that within a time frame, all children who did not attend school for 7 days are brought back to school so that they don't miss out on anything and they don't become child laborers, because if you let them drop out for a long time, they may get married, they may become child laborers, and they will need rehabilitation. The whole purpose is to avoid having to rehabilitate them, because you have a preventive protocol to ensure they come back to school within time frames. And it is the duty of the state to ensure their fundamental right. And if a child doesn't come to school even for one single day, its right to life is being affected. So
just 1 minute, ma'am. Just say this. Pursuant to the order dated 8/4/25 of this court, the Karnataka State Legal Services Authority has submitted its report. Full stop. A copy thereof be given to the counsel appearing for BBMP. Full stop. Who shall file a response on the report as submitted by the Karnataka Legal Services Authority within 2 weeks. The report shall be given within a period of 1 week from today. Then 2 weeks thereafter. Just say 2 weeks thereafter.
Copy of the same.
Copy. We are giving 1 week. Report. Our attention, Mr. Naganand, the senior counsel, has drawn our attention to an application being one of
21 and 1 of 22.
1 of 21 and 1 of 22, which are applications seeking intervention by certain children. Children, full stop. Though a reply to the said application has been filed, and Mr. Naganand opposes the application for intervention. During the course of hearing, it has been by the learned counsel for the applicants in this case that he has filed a note of submission wherein he has highlighted 5 points which he shall be urging in support of his application seeking intervention. We find that Mr. Naganand states that the said note of submission has not been given to him. Let a copy thereof be given Mr. Fanindra, learned amicus, states that a copy has been given to him. He shall share the
Please, ma'am.
note of submission with Mr. Naganan, registry, to also ensure that the note of submission as filed by the applicants in the said applications are also is brought on record, if not already there, before the next date of hearing. The petitioner in Mrs.
Katyayani Chamraj.
Katyayani Chamraj, the petitioner in person, who has referred to a memo filed by her on
1st of March, Your Honor.
1st of March 2025, with certain prayers. A copy thereof has been given to the counsel appearing for the state, ma'am. Ma'am, you have another extra copy? You don't have? Full stop. Full stop. The counsel for the respondent number 1, the state, shall file a response to the same. Full stop. The response must also, while giving the response, they should also consider the report submitted by the learned amicus curiae on this memo submitted by Srimati Katyayani Chamraj. You must have this also, the report also submitted by the amicus. The response shall be filed within a period of how much time, ma'am? Within 3 weeks from today. Just re-notify this petition after 3 weeks.
No, dear Lordships, may I refer to IA 1 of 21. IA 1 of 22 is for me to implead in IA 1 of 21. So reference to IA 1 of 21.
1 of 21.
Because they didn't make me a party in that IA.
IA 1 is to implead himself. Another IA is to implead you.
No, my lord. IA 1 of 21, he filed for intervention raising all these issues. They didn't make me a party. So I filed IA 1 of 22 to make myself a party in IA 1 of 21. Because they
Lords,
didn't make me a party. All the copies they did.
I have a soft copy of the Legal Services Authority report. I can share it via email to the BBMP Council.
Just sharing with the
I will.
Your Honor, under the Chief Secretary, there has been, because from the orders of this Honorable Court, an interdepartmental coordination committee has been set up, and it is supposed to meet every quarter. But no meeting has been held for 1 year now. So if you could kindly direct.
What is the committee known as?
Interdepartmental Coordination Committee under the Chief Secretary.
This is with regard to the RTE Act.
Under this petition only, Your Honor. And we can raise all these issues in that committee, to which they can find solutions based on our suggestions. But that committee has not met for more than a year.
And you will reflect this also, ma'am. Full stop. Just say that during the course of hearing, the Srimati Katyayani has also stated that an interdepartmental coordination committee has been constituted by the state government.
No,
my lords, by
on
this
direction
honorable
of this Honorable Court, Your Honor.
This court. And the said committee has not held any proceedings for the last 1 year.
Yes, Your Honor.
For the last 1 year. Full stop. He states that, yes, ma'am, what do you say? Appropriate shall be that the council appearing for the state of Karnataka shall take instructions and hold a meeting before and attempt should be made to hold a meeting before the next date of hearing. Okay, and the minutes thereof shall be placed before this court. You don't say attempt, we will say meeting shall be held. You will hold the meeting. Don't say attempt, cut it. Just give it after 3 weeks.
Your Honor, Date of next hearing.
We
I
are
will-
giving you, we are giving you. But are they being given, the notebooks, pencils, all those things? A lot of things to be done under this. And give it
29/7.
29 July.
Thank you, Your Honor.
Please.
Forty-eight, seal number 48.
Appear for the petitioner.
Okay, for the BBMP, respondent two.
But I appear for a proposed intervener. There's a new application, my lord, that has been filed through Mr. Arjun Rao, the learned advocate on record.
Copy is not served on this. I am for the petitioner. I don't know. Because matter is pertaining to the illegal hoarding and advertisement.
Seeking intervention.
Yes, my lord, I'm seeking intervention simply
Who are you?
because, my lord, I am in the advertising business, and my lord, because of what has been transpiring here, it affects my business, and my lord, what I propose to do and what I have been doing. I will, my lord, ensure a copy is given. I was under the impression.
Just give the copies of that intervention application to everyone.
It's not been given.
My lords, the matter was reserved for judgment in the earlier bench, my lords. The matter was completely heard. Matter pertains to advertising bylaws, which were placed before my lords.
Your Lordship, earlier occasion, these advertising agencies have come before this court. This court has dismissed it long back in 2019 itself, Your Lord. But they are not there. If they are agreed, they have to go with learned single. If any bylaw is, now bylaw has been placed now.
Just say we have
This
been
applicant
informed-
cannot be entertained.
We have been informed by Shri Nandakumar that intervention application has been filed. Filed for whom he is appearing. So let a copy thereof be given to the counsels who are appearing for the petitioner as well as the respondents herein.
Because it should be dismissed with cost, Your Lordship.
We will see.
Time and
The
again, they are
application
filing same advertising agency.
I would like to make a
And
submission on behalf of
these are the, Your Lordship, these are the persons who is responsible for the ugly Bangalore city, basically, Your Lordship. That's my
Yes,
responsible submission.
Give it. Yes, Mr. Nandakumar.
My lord, I appear, my lord.
But I'll see the copies. That's all I wanted to say.
What did you say, Mr. Nandakumar?
Connectivity issues.
I was saying I ensure a copy is served on everybody.
Yes.
And possibly once my learned friend sees it, he'll appreciate that it's not something that needs dismissal. I may have to be heard, my lord. I'll point it out. I'll make good my position.
Very well.
Lord, I appear for the BBMP, my lord. The entire case, my lord, relates to, it originated by Mr. Mohan, my lord, saying that entire city is being defaced and nobody is enforcing it. The Honorable Court has passed, my lord, a number of orders, At the course of the hearing, my lord, the court expressed that we must have a set of proper regulations. So, my lord, bylaws were framed and they were placed before the Honorable Court, my lord. Honorable Court, it was a draft form. Honorable Court looked into it, and my lord, in the light of submissions made by many people, some suggestions came. So those suggestions were also incorporated, and we have filed the final set. Now, my lord, it is ready for notification. But the court, my lord, had issued an interim order because at that stage the matter had been finally nearly heard fully. So their lordships were about to pronounce order. So they made an order, my lord, on 22nd of October. Your lordships may kindly see the order of 22nd October.
Yes.
The fourth paragraph, since the court is seized with the subject matter of the present public interest litigation relating to monitoring the regulation of hoarding and flexes which have been put up in the city of Bangalore, it is decided that the aforesaid bylaws shall not be notified without first being produced on the record of the present proceedings and approved by the court. This is what the lordships had, my lord, ordered. Then subsequently, my lord, there was a further order that this should be continued on the same lines. Now, my lord, in the interim, my lord, I have filed the revised bylaws before the court. And my lord, I have filed an application, my lord, IA number 1 of 25. In the prayer in that application, my lord, what has happened is these bylaws, my lord, enable the corporation to realize revenue by giving licenses for holding. It's all regulated in the bylaws. Now, my lord, we are losing 2 crores of rupees, 100 crores of rupees a month by way of advertising revenue. The Honorable Court, my lord, was expecting to pass an order. It didn't happen. So now, my lord, I have filed this application. My respectful submission is this, my lord. In a PIL, my lord, this is a legislative function. And the delay was on the part of, my lord, the BBMP prepared the draft. It went to government. All this was placed. So kindly permit us to give effect to this bylaw, my lord, because today, by virtue of your lordship's order, it is like preempting a legislation. If after it is made, my lord, anybody has any grievance, my lord, they are most welcome to.
We'll also hear it to Mr. Nagar. It was heard by the earlier bench, no?
No, what happened, my lord, was these amendments came about at the hearing stage. So we prepared the bylaws and we filed the bylaws. I'm only requesting, my lord, let this, my lord, it's a huge revenue impact for me, my lord.
You're right.
The matter, my lord.
What do you say?
My lord, what I'm submitting, my lord, your lordships may even say, my lord, subject to further orders of the court. If somebody is seriously aggrieved by these implementation, today, my lord, what has happened is there's no law, there's no bylaw, there's no revenue to corporation, and it is unregulated. The whole thing started with
The earlier along the arguments went. What is the basic challenge for the arguments need to be advanced?
I think, my lord, the basic challenge was the absence of proper regulation and enforcement. That was the main argument. So we have now formulated it.
Got it.
So if that can be, my lord, permitted, subject to, my lord, any orders that your lordships may make in future after hearing, my lord. Petitioner, my lord, has no objection.
18 January order, 18 January 24, for a moment.
The main argument, my lord, was that these flex boards are put up, my lord. They are made of some kind of plastic, and they put it up, all these political personalities, some function, they'll put everything, then they're all brought down, thrown away. And that is environmentally, it is causing degradation. That was the main argument. Now
this petition is based on the earlier order of the Honorable Supreme Court in MC Mehta's case, wherein the advertisement companies have approached the court.
2 weeks. We'll have it after 2 weeks. Just have it after 2 weeks.
Lord, your lordships may consider, my lord, making an order permitting us to.
What do you say on this, Mr.
My lord, I entirely, my lord, endorse what Mr. Naganand is saying. In fact, I only add that my fundamental rights also, my lord,
what do you say on this?
As far as petition, they already compared with, I filed my response and suggestions also. That has been now incorporated in this amended.
Everything incorporated. Yes.
Can be.
My lord, then it can
once this bylaw comes, because earlier.
Tell us one thing now. How in intervention application once it was reserved, and then
Lord, apparently there is an association whose application may have been dismissed. I'm not saying anything, but I'm, Lord, if it's my fundamental right that's been affected, that's all I'm pointing out.
It
What
was
Mr.
since when
Naganan
this
says, Lord, I
petition
wholly
was
endorse. I wholly endorse what Mr. Naganan says.
If he is affected by this this bylaw, my
To
lord,
have a
they
remedy.
have every remedy available.
TBMP may be permitted to notify this bylaws is the request.
In fact,
Absolutely,
You
my
have
lord.
a
I wholly
remedy.
endorse that.
You have a remedy. If you are
That
agreed
friend
by
is
the
agreeing, my
DG,
lord.
no, that's
My lord,
what
I
you are.
entirely
22nd
endorse
November
what my lord Mr.
2019.
Naganan says.
The same people have filed IA. 22nd November 2019, you will.
Mr. Nandakumar is
They
agreeing.
filed the IAS. All the IAS were dismissed. IA
I'm
10,
sorry,
11, 12.
I'm sorry to
of-
interrupt Mr. Mohan. I'm agreeing with what Mr. Naganan says, my lord. I'm entirely agreeing with him.
My learned friend is agreeing for enforcement.
If
Yes.
you are aggrieved, you can
Please.
challenge the virus.
In fact, my grievance is that there is a vacuum and I'm unable to conduct my business
so that's
altogether.
why, so why an intervention? Mr. Nagaran
My
is
lord,
saying.
because of the orders of this court, my lord, if Mr. Naganand is proceeding, my lord, on the basis of what is just fallen from him, I have no difficulty. That's all even I want. Because there is a vacuum and I am unable to conduct my business altogether.
So what follows? So you are
Complete ban
giving
on my
no
business
intervention.
effectively, my lord. That is what I'm submitting.
So then if the petitioner says, you also say everything, where is the difficulty then?
There is no difficulty. All of us seem to want the same thing, my lord.
Yes, so what?
Your
what
Lordship,
do you want?
public interest litigation. Attend to the removal.
Just 1 minute, please. Yes, Mr. Mr. Nandakumar, tell us.
Lord, all I'm submitting is that I have been in a complete vacuum and therefore I have not been able to conduct my business. Now that the BBMP is saying that they want to enforce it and are seeking, my lord, your lordship's leave to be able
You have
to do
seen
so.
that
That is
application?
also exactly what we want.
You have seen that application?
Seeks only permission
Yes,
to
I have, my
implement
lord,
the
yes.
bylaw.
No, but tell us one thing. Once
Yes.
these bylaws are put in place,
Yes.
what remains to be decided?
Actually, my lord, my submission is nothing will remain because
Now, everyone who is there part of the litigation, this petition, are satisfied?
actually, this, my lord, the petitioner, my lord, who comes before the court, his grievance was that this is unregulated activity going on. Now, the bylaw will regulate everything. If this is given effect to, if we have, somebody is
Yes,
affected,
Mr. Nandakumar, tell us.
they can challenge it in appropriate
Yes, my
proceedings.
lord. My lord, absolutely right. That is, I think, the correct course, my lord. As long as the bylaws are implemented, if anybody has a grievance, that right be kept open.
Do
Other
you
than that,
agree for
there
that?
cannot be.
When the petition is
Yes.
there, Mr. Nandakumar says, all you have to say is whatever is the prayer in the application that be granted, the whole petition goes. Is your application?
The IMR 1 of 25 is there, my lord. The whole case started on the ground that there was no regulation.
It's not there.
You can give your copy.
Sorry,
We'll
I
have it next week when the application is now there.
one copy, my lord. It's a
Just
very
give it to us.
2-page application. Prayer is only
We also go through it. Mr. Nandakumar.
very well. Very well.
Just have it next week. Just re-notify on Wednesday.
So grateful.
We'll have it on Wednesday.
Please.
I'm very grateful, my lord.
That's all. We'll come back. No, see, there's only one. See, the rest of the matters we'll be able to, we have to give you dates. We have a fixed matter at 2:30 that we are hearing it. So any urgency, unless there is a urgency, don't take a short date. We'll give you date as per our convenience. Okay, any interim order, please tell the court officer, she will extend it. Wherever there is an interim order. Otherwise, she will give you dates. Okay.
Your Lordship, kindly.
My lord, serial number 62, my lord.
Just 1 minute.
My lord, serial number 62.
Just take this one. That's right.
My lord's kind
Lord.
leave, my lord.
Who else is filing the submissions?
My lord.
Yes.
Serial number 88, your Lordship.
We'll give you date. We'll give
Lord,
you.
serial number.
You mention it at 2:30.
Lord, seal number 49, my lord, street cutting, man.
Your Lordship, see, 88 pertain to IA, hearing and IA has to be posted.
Court officer? Court officer?
Okay. Why is it not?
Hello.
Well, please.
Just 2 minutes.
What's happening?
Yes.
Lord,
Metro. Please.
Please, my lords. In fact, my lords, there's some urgency in this matter, my lords. If any date convenient to your lordships may be given. My lord.
No, if you
Because
see,
project is
we appropriately.
Please, my lord.
We'll give you next week, Mr. Shetty.
Please, my lord. Please, grateful to my lord.
10, 9.
9.
Number, ma'am?
9.
Huh. Huh. Arbitration proceeding restrained. You appear for the.
I appear for the respondent in one matter.
Oh. So there is section 9 order.
They have a section 9 order in their favor.
We'll look into it. It requires consideration. It requires consideration. You've also filed an appeal.
We filed an appeal.
37. Just give it, ma'am. What is the date given? What is your convenient date? 29 July. It's all right. You have section 9.
It's the same issue. Same issue.
You are protected. It's all.
But
Yeah. Recollect. Just take it. What is the this is a commercial appeal? What is the urgency? That will not make any difference. If you are convinced by your argument, we can extend the time or we can send it back. These are the two eventualities. That's it. We will have it next week.
Number 72, my lord. The respondent who one has referred contempt proceedings before case 18.
Pardon?
The respondent number 1 has already preferred contempt against in case 80, my lord. Please, my lord. So, my lord, it may be listed on 9th of July, my lord, if we are seeking to stay off the contempt.
When is the contempt listed? 16. We'll have it on 16.
Very well.
It's here only. Contempt is here only. You look into it.
Whether in serial number.
What have you, this is the date we have given.
The date has not yet been given.
What is the number you said?
72.
Ma'am, 72, give it on 16th.
Whether
Who is the other side? Who is the other side? You are appearing, ma'am, you are appearing?
Yes, my lord. My lord, there's an impleading application also.
No, impleading by be a third party.
My lord may grant me
Who are
some
you
time, my
concerned?
lord. My lord may
we are
grant me
impleading.
some.
We are
file
impleading
a-
applicant.
Now, what is the urgency? Leased it in respect of what? Is it an appeal, writ appeal? Okay. For what? Okay. Just give it next week, ma'am. We'll have it next week.
10/7.
When was the order, when was the impugned order action taken? When did they decided the application in favor of a third party? When did they? When did they, according to you, decided they are going to award to a third? Yeah, have it.
And secondly, I would like to draw attention to Salomon Mela.
Tuesday.
My application has been rejected on the ground that FIR has been registered against me. By passing an order, the police has been filed the plea report. They are not considered at all.
Look into it. Just give it, ma'am. Give it.
Meanwhile, petition copy may be served to me.
My lord, the copy may be served on me also.
Give it.
I think ಕಾಪಿಗಳು ಬಹಳ ಇರಬೇಕು.
ಸ್ವಾಮಿ ಇದ್ರೆ ಕೂಡ್ಲೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಕೂಡ್ಲೆ instructions, I'll get instructions immediately. No, it's all right, sir. It's all right. Beda.
Okay, tomorrow. Have it tomorrow.
My lord, meanwhile, copy may be served to me, impleading applicant.
Is there any difficulty? Give a copy. That's right.
Much obliged.
Give a copy. What is the difficulty? Yes. When is the date? Date in execution. Just have it after 2 weeks. See, once you receive execution notice, you can say you have filed an appeal here. Tell that. You are giving a date.
22/7.
Come, next. Thank you. Come, call the matters, man. And one fixed matter, yeah. Call up 230 matter.
230 moved. One matter is 230 moved, sir.
230 matter call up, no? 230 matter. Both are 230. Refresh 230. Call.
Yes, 230 moved. Sridhar Prabhu.
What is this, Mr. Prabhu?
Please, my lord. The issue is, my lord, we have sent a soft copy, my lord. I will only persuade your lord.
1 minute. What is the issue?
Yes. The issue is, my lord, the respondents before, the contesting respondents before your lordships are laying an interstate transmission line, my lord. That is only to the sole benefit of Kerala state, they say, and the transmission line is being laid, my lord. Now, before the single judge, my lord, I had challenged the authority of the third respondent, acting under some, my lord, permissions to lay the line. They are a third party, they are a private agency. How could they lay the line? One. Secondly, my lord, under section.
Challenge that.
Yes, my lord, the very authority granted to them. Section 68.
How are you concerned? You are
Landowner, my lord. On my land.
Very good. Okay,
Yes,
then-
on my land, now, my lord, under 164 and section 68 are the two sections under the Electricity Act, my lord, which contemplate the permissions to be granted. Now, my lord, the learned single judge says that an identical matter has been decided by a coordinate bench as well as by the division bench. On that count, my lord, the matter is disposed of. They don't file the objections before the learned single judge. The sole contention is it is covered by a judgment passed by the learned single judge.
What does the coordinate bench say?
Yes, the coordinate bench, my lord, extensively reproduces the order passed by the division bench, my lord, at page 86 of my writ appeal, my lord. I have reproduced from para 10.
What does the sum total?
The sum total is, my lord, that the permission under 64 and 164 and 68, there is authority vested with the Central Electricity Authority to delegate that power. There is ample power vested.
Delegate to whom?
To this private entity, my lord, the respondent before your lordship, the private entity.
To lay the cables?
Yes, to exercise the powers under 164 and 68, my lord. Now the issue is, my lord, that in the division bench judgment, my specific contention was that, my lord, the para 45 of that judgment, which is extracted in this order also, my lord. May I persuade your lordships to kindly see?
Well, one thing, Mr. Prabhu, it can be this full. Can you challenge the very authority one?
Yes.
You are owning a dwelling house or you are owning a property. That should not, the cables must not go above that.
Yes.
Yes. That must be the concern.
That's the only concern, my lord. There are other contentions as well.
Authority may be there.
Yes,
but in the given fact,
yes,
it cannot go over my house. Or
my
over
house,
my
and my
property.
lord, the tower is being laid in my land. Specifically, a tower is being laid. My specific contention was, my lord, that in the judgment that the learned single judge relies upon, the division bench judgment, my lord, at page 127, there is my lord, the extract starts, in fact, my lord, from page 86 onwards, and the relevant extract your lordships may see at page 127, that para 45 of that division bench judgment is, my lord, quoted.
Yes.
Thus, even in the instant case, learned senior counsel for the appellant submitted that alignment of the line for the purpose of installation of the overhead lines is yet to be finalized as regards the properties belonging to respondents number 1 to 40 writ petitioners is concerned. Needless to state, if in the event on such alignment, the proposed project is implemented on the land belonging to the so and so, they would certainly be entitled to such remedy, etc., etc. My respectful submission is, my lord, the division bench issue had become an academic issue because even at the time of writ appeal, the alignment itself was not finalized. I am rereading, my lord, for my satisfaction. They say that thus, even in the instant case, the learned senior counsel for the appellant, which is, my lord, my learned friend's client, submitted that alignment of the line for the purpose of installation of the overhead lines is yet to be finalized as regards the properties belonging to so and so. So, my lord, the entire judgment which the learned single judge relies upon is a judgment rendered on an academic issue because, my lord, the line itself was not finalized. What the learned, the honorable division bench says is line itself is not finalized. If at all they come and they change the alignment, and if the line goes on your property, you look into the matter, you take recourse to whatever compensation or other issues. Now, therefore, my lord, that judgment could not have been relied upon in my case because in this case, my lord, the tower is being laid in my land only. The contentions may be identical, but a judge.
What is the final conclusion?
Yes, the final conclusion is, my lord, the writ petition was dismissed. Page 134, 133.
So your concern is twofold. One is the line is going.
Yes.
Above your property,
and the transmission, the towers are being laid in my property.
One thing. Otherwise, in law, they can't lay or they put a tower.
Yes.
On your property.
No, lord, then they have to take recourse to, one is, my lord, to lay the line, there are permissions contemplated from the deputy commissioner under section of the Telegraph Act, my lord, section 10, 12, 13, 14. My respectful submission is that soon after this matter was disposed of by the learned single judge, they come and attack on my property. Now the work is going on in my property. My respectful
submissions are twofold.
Yes.
Or we have one fold primarily, permission from you to be taken.
Yes.
And from the deputy commissioner.
From the deputy commissioner.
These two things need to be.
Yes, my lord.
And
now,
you don't challenge the authority, their authority to put a tower on your property subject to any compensation need to be done.
No, that, my lord, I have also taken up a contention. In fact, my lord, that is part of my, it's one of my primary contentions. Telegraph Act is not applicable and Land Acquisition Act is applicable because it, my lord, involves acquisition. Because, my lord, under the Land Acquisition Act, the activities defined to be infrastructure include electricity and laying of transmission lines. And it is also my primary contention before the learned single judge also that Land Acquisition Act is applicable. That is one contention. There are other contentions as well, that how they are not. None of that is considered. And division bench judgment, my lord, which was passed on an academic issue, is solely relied upon and reproduced all throughout. And say, my lord, that I am unsuited.
There is no acquisition per se.
I'm a lord. I will satisfy your lordships on that's a lot a larger issue. If the requisition, lord, is for perpetual years,
Usage gets reduced.
Sorry, my lord.
Usage by you of that land gets reduced.
The line, my lord, is not. It's not just the aerial, my lord, line that passes by. The transmission towers are laid. And my lord, I have also written a letter. I have.
Ineffective. This portion. Crops can be grown. Crops of particular height. Chunks of land. Holdings sense that is 100 acres, 2 cents, 3 cents, small portions, becomes ineffective. The holding becomes ineffective. Is now cases to permission not taken from the from him. Who appears for the government?
I appear for the third respondent.
Government.
Transmission licensee.
You are the laying.
I'm the transmission licensee under the.
No, but tell us one thing, Mr. Raghavan, the permission required from Deputy Commissioner. Now, what kind of, it's just like.
The Telegraph Act, not under Section 10, I have to be authorized. Under 164 of the Electricity Act, I have to be authorized, which I am authorized. But this is an interstate transmission line being laid between Karnataka and Kerala. But it's across several.
But tell us one thing, we just want to understand, surely for me at least. Now, like you just walk in and say that I am now, not laying, effectively taking a cable from here. And no one has, can say anything. You cannot hear, you can do it. That's a better place or way to put it.
The interstate under 164, I have to not approach the Central Electricity Authority and get their approval. But then I have to show their plan where I am going to lay the lines along which route. And then there is a paper notification which I have to take out, informing which are all the villages through which I will draw the line. But therefore, they are notified. Beyond that, the law is clear. In fact, there are several judgments which I pointed out before the learned single judge also. This is not acquisition. This is a right of use. And therefore, the only remedy which is available is in terms of compensation, because what portion of the property where I am laying the towers or under which the line, over which the lines pass, I am only required to compensate them. Beyond that, and insofar as they are agreed regarding compensation, they can approach the district judge and Telegraph Act for enhancement of compensation.
May I, my lord, answer?
There is no question of intervention in this or being heard. In fact, when it's single judge, it's not correct to say he referred to only the division bench order. He refers to not at page 129 if your lordship takes from para 12.
There is no issue of alignment.
Absolutely no.
Everything is settled.
Yes, settled.
No. In fact, my lord, the alignment was.
No one villager can say, because it is a transmission line running across the state.
I respect.
Shift here because the whole alignment will then.
No, the judgment which has been referred to, please. It appears the alignment was not
at that point of time.
Was not settled. So, no, the observation it appears.
Thereafter, not at page 129, the lordship sees the learned single judge considers his contentions. It is not that the.
Lord, I'll complete my submissions. Just 2 more submissions, my lord. I'm sorry.
Kindly have a look at para 12 minute. Well onwards, page 129 minute, the internal page.
So what you say is, he has no say?
No say.
Yes.
You are within your rights to take the cable.
I'll answer.
And the only right he has is for diminishing value of the land over which the cable is being run, he would be entitled to a sort of a compensation.
Yes.
I should note, in fact, my lord, this judgment was passed in August of 24. He filed the appeal in December, my lord, with defects. Never moved the matter for 6 months. I'm on the caveat. Today, in the afternoon, my lord, he serves me a copy of the caveat.
Caveat had expired.
Lord, I have corresponded with them. In June, I have told, here is the compensation. Please come and take it. We have to lay the lines. This cannot be impeded any further. The person, there are issues of correspondence. And now, my lord, all of a sudden, my lord, when I have started, my lord, the foundation, my lord, is being done.
On his land?
On his land, absolutely on his land.
Yes.
You have started?
Yes.
Yes.
I can show the photographs, not
Tell
the.
us one thing, Mr. Prabhu, when was the impugned order passed?
Yes, my lord. It was passed in December, my lord.
You will not wait for the policeman to come and
No.
stand on
I'll submit, my lord. Why? I will answer that question, my lord. What he does is, my lord, when this matter was pending, when the writ appeal was pending, he goes before the learned single judge, my lord, for a blanket order under section 16. May I pass on? Lord? That is why, my lord, I moved the matter today on this count. May I, my lord, pass on this, lord, to show. He goes before the learned single judge with a mandamus prayer when the matter was pending. This writ appeal was pending. May I, my lord, read the prayer part of it at page 2. Lordships have it, my lord. Second page. This writ petition is filed under so and so, praying to direct respondent number 2 and 3 to exercise powers under section 16 of the Indian Telegraph Act, ensuring removal of obstructions and resistance by the landowners of the districts of so and so as to enable the petitioner herein to exercise powers under section 10 of the Act as conferred upon by it by respondent number 5 for laying the electricity transmission lines. Now, my lord, the normal course is whenever, my lord, power has to be exercised by the deputy commissioner, somebody has to file a protest petition that I am laying a line on his property. He is obstructing me. Please ask him to remove and take his compensation and go. But he files a blanket, my lord, petition before and he doesn't make us party. I try to implead that is not possible. I have filed a review petition. Now, my lord, he doesn't make any of the landowners a party. He wants a judicial order to substitute section 16 powers of the, my lord, the deputy commissioner to say, please give me police protection and allow me to lay the line. Now, my lord, I question myself that I have lost the case before the learned single judge, and my lord, he has every right to lay the line. Let us, my lord, until your lordship stays that in the writ appeal. Now, my lord, can an entity, private entity, Sterlite, he is a transmission entity, he says that I want police protection to lay a line. I will not issue any individual notices to any of the landowners. If they protest, it is their problem. I want a blanket order from the deputy commissioner that allow me to lay the line. That is, my lord, the 10. Now, I ask myself, suppose these powers are, your lordships pointedly asked him, do you not require powers under the section 16 Telegraph Act? You have to make a hearing, deputy commissioner has to pass an order. How does that? He addresses that issue through this writ petition, through a blanket order passed by a learned single judge. Now, my lord, even the learned single judge's order is also interesting. It is not a, lordships may see the operative portion, very interesting, my lord.
But tell me one thing.
Yes.
What was your scope of writ petition?
Sorry, my lord.
What was the scope of your
of his writ, my writ petition? Yes, my writ petition. The prayer was, my lord, that he has no authority to.
Who are you to challenge that?
No, secondarily, my lord, not to take any actions pursuant to that. Not just that. There are other grounds urged to show.
Come to 77.
Yes, my lord. Yes, my lord.
Read your prayers.
Yes, my lord. This WP under so and so, then vested in the joint secretary so and so of the so and so to chairperson to approve the so and so, and yes, my lord, to the prayer column, my lord, issue a writ of certiorari or any other writ or direction to declare that order number so and so passed by the first respondent Ministry of Power delegating the power of so and so, then vested with joint secretary so and so for approval of so and so, then vested with so and so is manifestly arbitrary, unreasonable, violative of. My lord, I had succeeded before the learned single judge in the other matter. That matter went up to division bench, and my lord, it was reversed. If the authority, if the in law, my lord, if there is no authority to delegate power, now, my lord, this is a very essential function given to Central Electricity Authority to see the transmission layout, how the transmission lines are laid, and give permission for my lord, to lay the line. That was delegated to this private entity. That I questioned. Then, my lord, I succeeded in yet another petition. That, my lord, resulted thereafter, it was reversed. Then Supreme Court also confirmed. There the issue was whether
So
68
now what is the final adjudication there?
final
Power exists?
adjudication.
Power exists?
Power exists under section 68, my lord. But 160, whether there is a power delegation possible under 164 was not, my lord, the subject matter. That is one aspect. Secondly, my lord, even under that judgment that was passed was on the premise that the line was going on my property. That was, my lord, negative. That is, you are not aggrieved at all. It was more of a moot court, my lord, contest. So therefore, whatever orders are passed were passed on the premise that the line is passing through my. He came and said, no, the line there is. We have not finalized the alignment at all. Why are you bothered? How are you bothered?
That's not the case here.
Yes, my lord. So therefore, what I am praying is, my lord, I am not party to that writ petition, my lord, where the academic issue is decided. I have raised independent contentions. Along with that 68 approval, I say 164 approval also, delegation is not possible. Like the way he was saying once.
How are you concerned?
I am, my lord, if my lands are being acquired.
That's a different argument. You can still sustain, you can make a, file a petition on that. Look here, insofar as your land is concerned, they may have an authority, but that requires a prior approval of the deputy
Central
commissioner.
government, yes.
Very deputy commissioner.
No, that issue is independent issue, my lord. Here, my lord, I am saying Telegraph Act is not applicable. Independent of that, I am saying, even if it is to be presumed that it is applicable, now kindly see, my lord, Telegraph Act itself is repealed by a new act under 2023 enactment.
We don't know what is the locus on that.
Sorry, my lord.
Okay. We have a serious doubt on your locus to.
No, but my lands, my lord, my property.
A different argument.
Yes, my lord.
Your land.
Yes.
They have an authority. It has been delegated. Surely you would not say so. You are more concerned about your land.
Yes.
Okay. Your land against acquisition. You may be concerned.
Yes.
Authority may be there, but they are coming to take over the usage on your land. That should be restrained because it presupposes an approval.
I have prayed that also, my lord. The first two prayers are on delegation 68, 164. Third prayer is any action taken pursuant to those permissions should be restrained. That should not be permitted. Independent of that, even 68, 164.
Where is your ground that a deputy commissioner need to be approved?
Now, my lord, I question myself. If they had a blanket, they were a delegate of the central government and they had every right to, then why did they approach the honorable court saying that direct the deputy commissioner to, my lord, pass an order under 16?
Possibly, you don't want any law and order there.
Sorry.
Possibly, law and order situation on the side.
If that is
That's
so,
the
my lord.
reason.
Correct. If police protection is yet another thing, you can file a simple, my lord, simpliciter saying, give me police protection. That's not the order sought. It says, direct him to pass an order under section 16 where landowners are not involved. Now, my lord, all that I'm saying is, even if it is to be treated as a simpliciter compensation issue, let the deputy commissioner call me and say, what is your problem?
Where is that power for the deputy commissioner?
Under section, they themselves say, my lord, section 10 and 16 in that learned
sure.
single judge's order, my lord. Lordships may see.
Subject to
Mr.
correction.
Raghavan.
This ground was not raised in the.
No, but tell us, it's
No,
a pure question. 1 minute. Pure question of law. Power, the deputy commissioner need to give an approval.
No minute.
Which is the provision? Show us.
Yes, Lordships may see, my lord. Lordships may see, my lord. Section, the oral order passed by the learned single judge, page 3. I'm showing this. Also, I'm saying that this act is repealed now, and I'll show that provision also, my lord, for a moment. Even presuming this act is applicable. Lordships may see, the petitioner's grievance is that so-and-so has not taken steps to exercise their powers under section 16 of the Telegraph Act. And, my lord, the owners of the lands on which the art to be laid filed a representation for impediment. That is, my lord, some of the landowners.
See, it appears, if you see paragraph 6.
Yes, my lord.
Reading this indicate landowners can approach deputy commissioner for concern for claim for just and fair compensation.
Even that I am saying, suppose, my lord, they don't determine the compensation at all and say, I will come and do a trespass, criminal trespass. I say, I will not go to the deputy commissioner was, my lord, directed to pass an order within 1 month and dispose of that issue. He doesn't call me, no notice is issued, that is independent of, no orders are passed is one issue. Second issue is, if that orders are pending, they themselves approach the learned single judge for those orders. When the orders are not passed, can they come and trespass on my property?
Right. According to Mr. Raghavan, he has informed you, look here, I have deposited a compensation there.
No. The application has to be filed.
entities are ready. He returned, he said, I'm not ready.
When the matter is, no, my lord, the fundamental issue is, what is the legal recourse available to a transmission licensee, private transmission licensee? Can he just criminally trespass on the property and lay a line and say, you come to me for compensation, I'll settle it? Or, sorry, second issue.
1 minute.
Sorry.
This is a huge issue which you are raising. What is this? The government doesn't have a power to, for the ultimate public interest to lay.
No, government has powers, my lord. Delegation power to a private entity does not exist.
Prabhu, to be very frank, prima facie,
yes,
we are not in agreement and you have no locus.
I am a landowner, my lord. Who else will challenge that power? That issue, my lord, compensation issue is not the sole issue. If there are legal impediments, they have to do it as per law. I am not saying.
Show us what is law.
Yes.
You show us what is the provision where the prior approval for even coming on your land,
yes,
and carrying out what they have been awarded,
yes,
by
yes,
the
yes, I'll show. I'm obliged. Lordships may see, my lord, this Telegraph Act was repealed with the new act. Even under the Telegraph Act also there are provisions.
When was it repealed?
It was in 2020.
So this is a prior to that or after that?
This, my lord, applies now because the list is covered by that period. None of us brought to the notice. Yeah. Sorry. Lordships may see, my lord, 12, 11 and 12. Any facility provider. Now, my lord, this is, my lord, the Telecommunication Act. There are also rules framed there under. First, your lordships may see, my lord, the section 11 on page 6. Any facility provider may submit an application to a public entity under whose ownership, control, or so and so the public property is vested to seek permission for right of way for telecommunication network under or along so and so. On receipt of application from the facility provider, the public entity subject to provision grant permission for all of the so and so, survey such property so and so, enter the property. So it contemplates an application.
You read it in any facility provider,
yes,
may submit an application to public entity,
yes,
under whose ownership, control, or management the public property is vested.
Yes.
Not concerned with a.
Next section. Section 12. Any facility provider may submit an application to the person whose ownership, control, and management not covered under section 11 is vested to seek right of way for communication network along with across so and so. On receipt of an application for facility provider, person receiving application may enter into an agreement specifying consideration as mutually agreed for, undertaking surveys as may be so and so, establishing, operating, maintaining, repairing, replacing, augmenting so and so. The facility provider shall do so as little damage as possible, so and so. Now, my lord, there are rules framed under this act. May I show, my lord, the rules also? Under this, there is chapter 5, which details a detailed procedure to be followed. That's why, my lord, the Union Legislature was conscious that these questions, the private entities will say, where is the right? So therefore, my lord, these rules are framed. May I, my lord, pass on?
Where is this ground taken, Mr. Prabhu?
No, this issue, Lord, grounds are that Telegraph Act is not applicable to me is the ground. But since, my lord, that Telegraph Act, now that I am not able to take your lordships to that contention and demonstrate, I am presuming against myself that Telegraph Act is applicable, and even if it is applicable, how, my lord, I am entitled.
Where is that ground
yes,
taken?
I'll show.
See, for the learned judge to apply.
Yes, that's what, my lord. I will show. I will show to your lordship. Lordships may see page 160, page 166, my lord. For a moment.
Makes it very clear that the Telegraph Act continues.
ಆಗ್ಬೋದು ಅಲ್ಲ ಅದಕ್ಕೆ ನೋಟಿಫೈ ಆಗಿಲ್ಲ ಅದು ನನಗೆ ಐ ನೋ ದಟ್ ನಾನೇ ಅದಕ್ಕೆ ನೋಟಿಫೈ ಆಗಿ ಆ ಸೆಕ್ಷನ್ ಇಸ್ ನಾಟ್ ನೋಟಿಫೈಡ್ ಅದು ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದೆ ಸೆಕ್ಷನ್ ಇಸ್ ನಾಟ್ ನೋಟಿಫೈಡ್ ದೇರ್ ಆರ್ ಟೂ ನೋಟಿಫೈ ಸಾರಿ yes lordships may see 166 of my appeal memo, my lord. 165 in fact, I'm so sorry. I have said that, my lord, the word work under the so-and-so, under Indian so-and-so are not identical. The words electricity supply line in 1910 was replaced by the word electrical line so-and-so, so-and-so. Then your lordships may see, even though 1910 Act brought only supply line to the ambit of the word work, the Act expanded the definition of the work by including transmission line also. And from the combined reading of 165 of so-and-so, it is clear that transmission licensee cannot acquire any right without following the procedure prescribed under the Land Acquisition Act. Then petitioner submit that Right to Fair Compensation Act so-and-so was brought into force with effect from so-and-so. Then, my lord, under so-and-so, the act relating to the land acquisition, compensation, rehabilitation shall apply when the appropriate government acquires public purpose, and it shall include the following purpose for infrastructure projects. Then, my lord, there is a central government notification of 27/3/2012, which says that electricity generation, transmission, and distribution are infrastructure works, and therefore the Land Acquisition Act applies. That was my contention. Now his contention was, no, I have power under the Telegraph Act. I, my lord, said, now if it is not applicable to me at all, then I don't have to show the procedure under the Telegraph Act. But I am presuming worst against me, because I have not, my lord, persuaded your lordships and, my lord, taken through those provisions. I am saying, even if the Telegraph Act is applicable to me, then, my lord, there is a rule framed. What happens, my lord, for each tower to be laid, they have to go to the deputy commissioner and say, this is the tower to be laid, a prescribed fee has to be paid, and after the receipt of the fee, they will grant permission for laying of the lines. So they know all that. Therefore, my lord, they filed this my lord, writ petition before the honorable single judge, saying that please give us permission, without making any one of us a party. Now I question myself, my lord, suppose I'm a project proponent, I want to lay a line, I want to bypass all those obstructions, individuals who come in my way, and say, I go to the learned single judge and say, please give me a blanket permission, direct the DC mandamus direction to give me a protection. Is that permissible? Okay. Those are larger issues, my lord.
The only thing is, only plea is that they require permission from deputy commissioner.
That is, my lord, at this stage. At this stage, I will also, my lord, persuade your lordships, my lord, even much. I will argue. I am arguing against myself, because the Telegraph Act, my lord, is now presumed to be, my lord, applicable to me, and I have placed this also. There are other contentions also, my lord. It's not a main hearing. I understand, my lord. All that I am praying is that if the work now completes, suppose, then, my lord, the writ petition itself becomes infructuous. All that I am saying is,
we are not satisfied, at least surely not on the first aspect of your argument, that even the delegation, even the power of the central government, we will not.
No, my lord.
At your behest.
I am saying, my lord, even presuming that, my lord, I'll keep it aside. Now I am saying, my lord, at this stage.
Deputy commissioner, we will examine.
Yes.
Yes, Mr.
And you have looked at section 16.
Tell her, Mr. Raghavan, now surely there you are using their land, they require some compensation to be granted. You may dispute, he says, under the land acquisition, you may contest that.
So that the law is clear.
Very well, no. But today, till such time, any compensation is determined, any permission is taken from the deputy commissioner.
The permission of deputy commissioner does not arrive.
Very well. Now for you, let's assume for a moment, deputy commissioner per se, there are possibly two kind of a, permission. One is to use this land belonging to an individual citizen to be used for, using for not laying, but taking the cable. One. Two is for, according to Mr. Prabhu, even laying or even installing a tower, you may require a permission from the deputy commissioner. That's one. The third aspect of it is, before you can go ahead with that, would you or will you determine the compensation that need to be given to him before you work?
But I have already determined, I will just respond on the compensation aspect. In fact, because they had served the papers today, I could not place it. But there is correspondence where I have already, we have indicated across different villages at what rate it will be fixed. That has been published in the offices of the local revenue officers. As per those rates, we have fixed. We have intimated to the appellant here that this is the amount which has been fixed as per this. Please accept the compensation and allow us to lay the line. Even now the DDs are readily available with us.
So you say this, you have determined the compensation.
Yes.
Now, if you have to install or you have to erect a tower, would you require any permission from the deputy commissioner?
No.
May I answer that?
Sorry. One. Two, now according to you, you don't require any permission, even though the land belongs to a private individual, from the deputy commissioner to pay it. Okay, these are the.
Yes. I will answer.
This was never the contention before the single judge, not urged before the single judge that approval of deputy commissioners has to be taken. Kindly have a look at section 16 of the Indian Telegraph Act.
Well, now
Reference
that
is being made to a separate petition filed, which is not the subject matter of challenge here before the Lordship. The order not which has been passed with the other petition of 2024 December, which is being pointed out to the Lordship. That is not the order under challenge. I filed a separate writ petition because the deputy commissioners were not acting on my representation to exercise their powers under section 16. It is in that regard, not the learned
16 powers includes?
Not for him, kindly have a look at not for him to remove obstructions. Kindly have a look at section 16. If the exercise of powers mentioned in section 10 in respect of property referred to in clause D of the section is resisted or obstructed, the deputy magistrate may in his discretion order that the telegraph authority shall be permitted to exercise them. If after the making of an order under subsection 1 any person resists the exercise of those powers or having control of the property, does not give all facilities for their being exercised, he shall be deemed to have committed an offence under section 188. It is for this purpose, not as your Lordship not rightly pointed out, it will not be a law and order problem if I am resisted. Therefore, I had approached, it's not only in relation to this petition, but there are several other persons who had raised opposition. Therefore, I had asked the deputy commissioner to give me that benefit of this power. But it is not that I cannot exercise those powers without the deputy commissioner. If I require, if I am resisted, then it's up to me to go to the deputy commissioner and obtain his orders. And the consequences is that it will be an offence. Then kindly have a look at para 3. If any dispute arises concerning the sufficiency of compensation to be paid under section 10, clause D, it shall on application for the purpose of either of the disputing parties to the district judge within whose jurisdiction the property is situated be determined by him.
now,
So they have to approach the district judge. But I may also point out there are other petitions by other landowners. All of them are not raising objections. Those were disposed of saying you have your remedy under section 16 to go to the district judge insofar as insufficiency of compensation. But no orders were not passed insofar as prohibiting me from proceeding. But this is a interstate transmission line, not in public interest. Already there have been delays in this in the laying of this line. All that, in fact, the Lordship sees the division bench also notes the remedies for compensation. Ultimately, public interest would prevail over private interest. Therefore, the Lordship sees this is the only provision under which deputy commissioner is to be approached. Otherwise, my powers emanate under the Electricity Act.
Yes.
Kindly have a look at the Electricity Act.
Sir, 1 minute. Which are those provisions?
I'll pointedly answer. Lordships may seem, Lord, the rules framed now, which prescribe the procedure to be adopted by the service provider, how the transmission lines have to be laid.
Those does not apply at all to this.
Yes, I will not show that.
The Telegraph Act is not.
No, are you a service provider?
Yes, he is. Transmission license, whoever, Lord, lays a transmission line or a transmission.
This new act has been pointed out to your Lordship.
Lordships may seem, Lord.
Kindly have a look at section 1, clause 3.
Allah, he was.
One second.
Allah, none. I just produced a document. I'll finish my submissions. Lordships may seem, Lord, section 8.
Just 1 minute.
Yes, section 8.
What are these?
This is rules, my Lord, called.
Named under?
Yes, they are under the Telegraph Act 2023, my Lord. The rules are called the Telecommunications Right of Way Rules 2024, my Lord. And Lordships may see section rule 8, rule 7, my Lord, for a moment.
Not under the Telegraph Act. It's under the Telecommunications Act.
The Telecommunications Act. I'm sorry, which repealed the Telegraph Act. My apologies.
It does not repeal the Telegraph Act. It does not repeal the Telegraph Act. Kindly have a look at what section 1.
Now the whole
He is saying it's completely new.
No, under which?
No.
1 minute. Under which provision of the statute, any statute, your power to lay the cable or put the cable is under the Telegraph Act?
Electricity Act read with Telegraph Act.
No telecommunication?
No, because your Lordship only sees Telecommunications Act.
Telegraph.
It
So
says
Telegraph, does it repeal the Telegraph Act?
Section 60 has not been brought into force.
That's what is my case also, my Lord.
Section
Let's
60.
see, let's see that.
Can you have a look at section 60, bro?
Where is the repeal provision here?
Yes.
Legally, section 60.
61, my Lord. Subject to the other provisions of the section, enactment namely so and so are hereby repealed.
And this section has not been notified.
And
under
notwithstanding such repeal, the provisions of so and so aforesaid, anything done or taken, including any grant license so and so, that, my Lord, that is mentioned. And kindly see, my Lord, 3. That says provisions of part 3 of the Indian Telegraph Act shall continue to apply to all cases pertaining to laying of the transmission lines under 164, as the Indian Telegraph Act has not been repealed, and so as it has not been repealed, as if the so and so has not been repealed, and the provisions of so and so shall continue to be in force in reference to 164 till such time as 164 is amended.
It still holds the field. Telegraph Act to the extent of.
Yes, even
the part 3.
Yes.
Just make section 60 has not been notified at all.
Notified.
Correct.
Section 1. Section 1 clause 3 says.
So the effect is
If
the
there's no repeal.
Indian Telegraph Act stands.
Yes.
And so also Indian Wireless Telegraphy Act.
Please.
Even then, my lord, kindly see section 16 for a moment. Kindly see, my lord,
Now we are on the
16.1.
Telegraph Act.
Yes, even then. Exercise of powers conferred, Lord, I'm sorry. Exercise of powers conferred by section 10 and disputes as to compensation in case of property so and so. If the exercise of powers mentioned in 10 in respect of property referred to in so and so, to that section is resisted or obstructed, district magistrate may in his discretion order that so and so shall be permitted to exercise them. This order, my lord, has to be passed to trespass. It becomes a legal trespass then. If suppose the deputy commissioner passes the order under 16.1, it becomes legal. Not until then, because the order, my lord, under section 16.1 specifies the amount of compensation to be paid and other conditions, my lord, imposed for that trespass. Until then, no. Now, my lord, at this stage,
Mr. Prabhu, it's like this.
Yes.
10 will always come into play.
Yes,
10
please.
is there.
Yes, please.
But someone is resisting exercise of power
Yes.
under 10,
Yes.
then 16 will come into play.
Yes, my lord.
That's
I
how-
have resisted now, and for this obstruction, they have to go to the deputy commissioner and get an order against me, my lord, for them to trespass and then, my lord, enter my property.
So you are resisting them.
Through the writ petition, also, my lord, there is a reply also received. May I, my lord, show that my learned friend was talking about the compensation. I'll also show, my lord, the latest reply received from them.
Mr. Prabhu, I think bottom line is your compensation.
No, my lord, even if it is so, at this stage, my lord, even if I have utterly failed in persuading your lordships that, my lord, the Telegraph Act is not, all that, my lord, is another issue. That is subject matter of this writ appeal. But now, without there being an order from the deputy commissioner, my lord, I have filed a stay application. In support of that, I am saying, if, my lord, the matter is pending, and I have said, my lord, there is no order passed under section 16 by the deputy commissioner. They approached the honorable single judge. And now, my lord, if the...
All right, Mr. 10, you can't argue on 16. 10 is the power for him.
Yes.
If you are resisting,
I have
then
resisted.
They will take recourse.
I
to
have
16.
resisted. And now see, my
Take
lord,
recourse to.
his
Very well.
reply.
If you are resisted, we will not come to your aid. Let's be clear.
Sorry, my lord.
We will not come to your aid. They are discharging a duty, ultimate public interest.
No, my lord, that the transmission line was opposed by Karnataka, saying that our power is being, my lord, given to,
Let's not
it
go
will
into
destabilize
that.
the grid.
We are on a pure legal issue.
There is no public purpose at all, my lord. It is only a private interest involved, and against the public interest is on my side. The people are losing land, and, my lord, on my land the line is being laid. And they say, kindly see, my lord, the response given on the public interest element. I'll show that to your lordships. What is the public interest involved? Lordships may see, my lord, para 5, para 1 itself. I'm so sorry. This is the private in first paragraph. Now, this is in response to the obstruction that I call that Udupi so and so is a special purpose vehicle establishing so and so through a bidding process on so and so REC that your lordships may skip. Kindly see, my lord, para 5. The so and so project is a nationally significant undertaking conceptualized on the request of Kerala Electricity Board. Its benefits include adding so and so megawatt power to capacity of southern grid, ensuring so and so, then adding over 1000 megawatt to so and so. Completion of the project will improve reliability. That's what they say. Then, my lord, kindly come to the aspect of the my lord, conversion of land and right of user. Para, my lord, 8. To clarify further, so and so does not acquire ownership of the land for the purpose of installing transmission lines. Instead, the company operates under right to user principle, meaning that only the right to lay, maintain overhead transmission lines is exercised. I stop here. Now, what about the tower, my lord, that is being constructed on my land? They are giving an impression that it is an aerial project. Hawaii. There is no grounded transmission tower. Nothing, no transformer.
Compensate for the land used for putting it out.
No, my lord, I'm saying for that they have to go under section 16. They have to. There is no compensation part is undisputed. All that I'm saying is they try to give an impression that, my lord, where is the right of user? Where is the acquisition?
think to our recollection also, we got power grid. You know, that area which is being used on the land
Yes.
to construct or to put the
Yes.
tower, they compensate for that also.
Correct, my lord. I don't dispute on that. But to say that no permission is required, suppose, my lord, I go and construct something on somebody else's land.
You know, the permission which you are talking of 16 is different in a different context.
No, but to enter my land, my lord.
Is in a different context when there is a resistance. 16 is the power to.
Correct. Then, my lord, the DC says that this is the compensation awarded to you. Now you allow him to, my lord, go and lay the line. Now, where is that order? I question myself, my lord.
Mr. Raghavan, you have that order?
No.
Of compensation?
Our communication not we have.
Give it to Mr. Prabhu.
Not to me. The DC should, my lord, say that. Not to me. Offering. Now, I resisted that.
DD is also not DD.
DD Allah. The DC, not DD, my lord. DC. DC's order has to be there. Suppose I say, you take this money and I'll trespass.
No, DC has to give you.
The order, the DC has to say that this trespass becomes legal. That is one element. Now, my lord, even I have not even argued the point that Telegraph Act is not at all applicable.
No, how do we get that? Come to 16. 16 follows 10.
Correct.
That's right. Now read it.
Yes. If the exercise of powers mentioned in 10 in respect to
So 16
10,
follows
10,
10.
yes, my lord. 10 says, my lord, that telegraph authority may time to time place, maintain so and so, provided that telegraph shall not exercise powers by so and so, established and maintained, so established and so and
This
so.
is the enabling provision.
Enabling provision. Correct, my lord. And this is the charging section. How to exercise that power.
Very right.
I bow down. Now, my lord, therefore I am saying, now, my lord, I am also before your lordships to say that this act itself is not applicable. Because, my lord, there was a inquiry, I went into that and showed.
We'll have it some other day. We'll hear you leisurely.
But till then, my lord,
Nothing till then.
No, it
No,
will
Mr.
become
Prabhu.
infructuous, my lord, otherwise.
Well, that's for you to take a call. We are convinced, at least prima facie, yes, not in your favor. On this compensation, on this, we will look into it.
No, my lord, I am not on
Yes,
compensation
notice-
at all.
Notice, who accept notice for union?
I have
And two, I
already
accept notice.
served.
Are accept notice.
For 1 and 2 minutes, respond number
1
1
and
and 2.
2.
Lordships may have it, my lord, earliest convenience. I will, my lord, show the entire
1 and
spectrum
2,
of the act.
3, Mr. Raghavan, who is briefing you?
Rajeshwara PA.
Okay, and what about this Karnataka power
My
transmission?
lord, one last aspect. My specific contention in that has been that, my lord, the land has to be converted. This is, my lord, my specific contention.
Converted
To which, for non-agricultural
For
purpose.
non-agriculture purpose.
Yes. That has not been done, and therefore, my lord, I made that representation.
We'll ask them to file their submissions. We'll look
No,
into
if the conversion itself is, my lord, not done, and at this stage, my lord, if they want to, there is, my lord, Shankara Textiles case, there are a number of cases. If conversion, this is patently against the established law, that, my lord, the land is not converted.
Where is the plea before learner single?
It is, my lord. Lordships may see, my lord. No, the line was not laid.
But tell us one thing, after
Yes,
the
please.
line is laid, the identity of the land continues to be agriculture.
If the transmission tower is, my lord, erected,
That's only to that.
that has to be converted. I am not saying, my lord, the aerial portion has to be converted.
We'll see that.
The lordships may see, my lord, if without conversion, kindly see, my lord, the
1 minute.
response given by them against this plea.
Yes, for Karnataka power, for notice to 4, then 5, 6, 6, 8, so and so, notice we issue to 7, returnable on. The parties who have been served today before the court shall file their submissions within 6 weeks. That's it.
Lord, may I persuade this to your
Re-notify
lordship? It shall not be taken as a permission to lay the line, is what the learned single judge said. Without taking any approval, my lord, they are.
We have not said anything. We have just issued notice. There is no restraint order. That much we know. That's all.
No, let them take permission and establish the project.
Say nothing, Mr. Prabhu.
Grateful.
Thank you.
Grateful.
18-8.
Just take it. Otherwise we will not be able to complete it. Next. Yes.
Serial number 7, my lord.
Item 7.
Item number 7. Gulbarga Fort. Please.
Now, yes, ma'am. You look at this one.
Please, my lord.
Yes,
Please, my lords, we have filed affidavit, my lords, on 24th February 2025. My lords, we have given our affidavit is in detail. May I request my lords kindly, please.
The only thing is what we have been told is now a layout plan is being.
Please, my
for
lord.
them to relocate.
Please, my lord.
People who are there.
Please, my lord.
Now, what is the time process?
My lords, the approvals, may I please put on record?
You don't require.
Please.
Layout.
Please.
The layout will take its own time. For
Please,
development.
please.
The dwelling units will be erected.
Please.
Will be shifted there.
Please.
It will be a huge time.
Please.
Ultimately, we are concerned with an archaeological site.
Please.
The remedy must be instant.
Please.
So,
Please.
how many people are there?
My lords, may I draw my lords' kind attention to page 15 of my affidavit, my lords. I have clearly given an undertaking there in the form of an undertaking. No, it was served on that day. It served on 24th February. Yes.
What do you say, Mr. Khan?
They have to do it as soon as possible, my lord.
My lords, may I draw my lords' kind attention to the difficulty here in this particular case. This is a case, my lords, where the monument, my lords, has a mosque inside. So this mosque has been used for purposes of prayers. This mosque predates even our India. It's more than a few hundred years old, my lords. Act came into existence in 1956. Prior to that, in 1951, under the Hyderabad States Act, my lords, it was notified as a national monument. Since that came into existence, till 2018, till filing of the writ petition, PIL, my lords, no action was taken against these people. These squatters, so-called squatters, are none other than the muezzins, the preachers of the mosque. They're in charge of the upkeep of the mosque. And the 282 members who were there, it is their descendants. As on that day, before the act came into existence, my lords, they were permitted to stay there. Once the act came into existence, the procedure is prescribed under the act, my lord, to evacuate any encroachers or squatters there. That steps were not taken. So we brought it to the Honorable Court's notice that under section 19 of the act, it is necessary for the central government to hear all the parties and pass an order in case they did not hand over vacant possession. Once we brought that to the notice of the Honorable Court passed an order directing them to take steps. That is the order which is passed 19/11/2003. 2000, where is it? Yeah, 1 second. One second. 1 year time, my lords, in para 36 of my affidavit, I've given an undertaking. I request my lords to grant us 1 year time to rehabilitate them in that particular land, because all the approvals are obtained. 282, my lords. We have taken it as 282 families, my lords, because please, no, as on today.
What has to be removed is a little less.
My lord, the delay, in fact, since the day they issued that notice, as to who should bear the cost of this evacuation. My lord, it is a property which is national monument, which is owned, which is in the care and custody and upkeep and guardianship of the central government. These evacuees or the so-called squatters have been there even before the act came into existence. So from the time when the central government was in custody of this particular property, no steps were taken. So we have already given more than 3 or 4 occasions, my lords. We have given them written letters to respondent number 1, saying that this could be the cost of evacuation. It's not more than few lakhs. They refuse to part with any money, saying that statutorily we do not have to part with any money to ensure that someone is evacuated. My lords, keep in mind, my lords, this is a property where even if a police officer has to enter, it is with the permission of the particular authority. It's a monument, national monument. Please, archaeological survey. Even if I have to do anything, my lords, in such case, may I draw my lords' kind attention to paragraph 11, my lords. Para 7 onwards, my lords, it clearly, chronologically, my lords, para 7. Assistant Commissioner of Kalburgi, who was representing the Deputy Commissioner of Kalburgi, filed an affidavit whereby it was stated that unless an order passed under Section 92 of the 1958 Act, the Deputy Commissioner Collector cannot take steps for eviction of the occupants of the protected monument. Further, it was stated that the provisions do not empower Deputy Commissioner to vacate the encroachment in the protected monument by using force. It is humbly submitted that after filing of the affidavit, the Additional Director General, Archaeological Survey of India, vide his order dated so and so, dated 9/10/2019, in excess of his powers conferred by the Act under Section 19(2) Act of the Act, issued notice to all the encroachers within the Gulbarga Fort. Since the encroachers did not respond to the notice by the aforesaid officer, the Additional Director General, ASI, by an order dated 5/12/2019 under Section 19(2) of the 1958 Act, issued to the Deputy Commissioner, directing him to ensure removal of the encroachment from within the fort area. It is submitted that on 23/11/2020, a letter was addressed to the ASI regarding the cost of demolition, which was estimated at the time to be at.
Lord, yes, no, please, my lord, would your lordship take up the order dated 6/1/2025?
My lords, para 11, my lords, specifically extracted, my lords, directions earlier, where this issue was left open, and this issue was to be settled.
To me, my lord,
despite
may I
that, my
answer
lords,
this?
despite that,
question
we have
was for
taken
me.
steps
No,
to
Vijay,
form a layout. One
question is for
second,
me.
please.
That question is for me. So, no, my lord, what
30th June 2021, my lords, and para 11, please.
Lord, 6/1/2025 is the order. My lord, it says a fairly lengthy order, but may I read from the beginning? This petition is in the nature of a PIL, makes a grievance about the illegal encroachment which have been admittedly found within the precincts of Gulbarga Fort. The PIL has prayed to implement the order dated 14/12/1998, passed by respondent number 1, ASI, to remove illegal encroachment. It's a matter of not only serious concern, but deprecable, as well as that a place which is recognized and declared as a national monument, the encroachments were permitted to be perpetuated. Notwithstanding the order passed as far as back 1998, no action has been taken by the respondent authority. Entire subject matter assumes serious dimensions, more particularly in view of the order dated 8/11/2019, passed by this court in the course of proceedings of this petition. In the said order, the court noticed the contents of the affidavit filed by the respondent, in which it was stated and admitted that at least 282 encroachments were found in the protected area, and that show cause notices were issued to the encroachers. Yes, so Lord, I have issued show cause notices. It is not my responsibility. Even in this order, your lordships have not said that we have to give them any house. Your lordships have said only give them a fair opportunity. Lord, I do not want to take up upon myself the responsibility of giving them a house. They are squatters. Lord, I don't agree with my learned friend's submission that they are all there since time immemorial.
No, no, even if they're squatters.
That archaeological survey should give them, the house.
No, I thought he said
no.
central government should bear it. If that is.
Intent of the act also, but the only thing is what's involved is now means, now you have seen this order of 6/1. That's right. It doesn't contemplate the sum total of this order is the encroachment must go.
Yes.
That's right.
Yes.
Now a stand has been taken by the state government that we intend to provide them the alternative dwelling units for them to shift out there. Yes. That's right. For which we have created a layout, all those constructions will come up, then they will be shifted out.
Yes.
What do you have to say on that?
Lord, they have to do it because the direction, my lord, in the very same order at para 8, my lord, may I take your lordship to that order, para 8.
18/11/2019 order, which my learned friend places
Just
reliance
let me
upon.
read, my lord, there is a question asked to me, let me answer that. Lord, para 8, item number 2 and 3. Respondent to regional commissioner shall file his personal affidavit to clearly point out as to what prevented the said authority from complying and obeying the directions in the order dated 8/11/2019. Affidavit shall specify as to why the compliance order is not valid. Next one is important. At the same time, respondent 2 and 3 shall submit before the court on oath the roadmap and the mechanism which may be implemented by the authority to remove the encroachment and to clear the fort, which is a national monument. Lord, kindly see the direction to me. To me, it is respondent number 1, Superintendent ASI, shall file an affidavit with pictorial depiction of what steps have been taken and they are now going to take to protect the monument, to maintain its original status and to prevent deterioration. This have complained. But my lord, to removal, it is the state's responsibility. Yes, my lord. Yes.
Shall submit to the court as the roadmap and the mechanism which will be implemented by the authorities to remove the encroachments
And to clear the fort, which is a national monument. So therefore, my lord, my respectful submission is the state has to provide a clear roadmap. If they have acquired the land, my lord, they should furnish details and they should give a clear roadmap
My
within
lords.
the, I do not find a, I
No,
do
it's
not
in my
find a,
affidavit. Please.
I do not find a timeline there, my lord. There should be a timeline. Within
my-
the first 3 months, so and so milestone would be achieved.
My lords, page number 14 of my affidavit, my lords, the affidavit of the Deputy Commissioner, paragraph 36. Prior to that, my lords, may I bring to my lords notice what has transpired? Please, before that, my lords. My lords, paragraph 14, my lords, 11 and 12 refer to my lord's observation as to who should bear the cost. My lord, paragraph 14, how the steps were taken. It is submitted that the important points of the proceedings dated 16/5/2022 are hereunder. The occupant should extend cooperation to vacate the premises. The representative of the occupants stated that they were ready to vacate the premises. It was their demand that certain religious customs to be followed in the mosque and related mahzars or tombs with the fort. My lords, this has to be addressed by the central government under section 16 of the act, my lords. And further, may I draw my lords' kind attention to the relevant the affidavit, annexure R4, my lords, where the representative of the ASI is very much present. He is party to these proceedings. Nothing has been done so far. Nothing in the, my lord, this mosque which is in place, we have convinced the squatters to move out. My lords, now there is another issue with regard to how this mosque could be used once. Please, please.
Are you saying that any monument which is an archaeological site cannot be used for prayers?
No, I'm saying it can be, should be. That's not my case.
So there are many monuments being
It should be. They should be permitted.
so that as a mosque can it still be used?
Yes. Yes, sir.
Question is the squatters who can't be there inside, those they should be relocated to a
Please,
different place.
please.
Intent only.
Please.
That is what need to be done.
We have done that, my lord.
How would we do it now to say that layout, construction, then 1 year will testify?
Please, my lords. Please, my lords. Please, my lords. My lords, may I draw my lords' kind attention to paragraph 16, my lords, where I have taken steps. It is submitted that 5/12/2023, a letter was addressed to the Commissioner of City Corporation and Assistant Commissioner of Kalaburgi Subdivision to conduct a joint inspection along with the ASI and to submit a detailed report. The copy of the said letter is enclosed herewith as an layout is in, please, my lord. The timeline which I seek permission for is in para 36.
In para 36, there is no details about that proposed layout.
No, my lords. I have sought for an approval. May I draw my lords get kind attention to para 32 onwards, my lords. Para 32. After the meeting to which even the ASI was a party, it is submitted that since the ASI has refused to bear any cost relating to rehabilitation or relocation of the encroachers in February 2025, the district administration has come up with an alternative solution. 15/2/2025, following the discussions on 11/2/2025, a proceeding was conducted whereby a government land measuring 5 acres is reserved in survey number 101 of Malgatti for rehabilitating the occupants of Gulbarga Fort by forming a layout and sites. The order reserving land for rehabilitation is enclosed herewith in annexure R29. R29, there is clear distance. My lord, what happens, my lords? The layout, we have to lay the roads, electricity connections have to take in UGD because now it comes within the. Please.
We have seen.
No, maximum. Yeah. Please.
15 days, 20 days, everything giving out.
Please.
Things can be done.
1 year, my lords, it's a reasonable time frame that we seek from, my lords. We pray for. Because we don't want to seek further extension. It's the outer limit. We may do it within 6 months, as my lords rightly pointed out.
Yeah, I think you better take instructions for using the data. And then you will file.
My lords,
Periodical reports giving the
Please, we bow down, my lord.
Actually,
bow
4
down.
months have already lapsed. From February,
My
4
lords,
months have
it's,
already
it's
lapsed.
their house. They don't want to clean up the process. We are helping them do their job.
Are you seeing serious?
My lords.
So you are not talking of any rehabilitation
No,
plan?
no, no. We are doing it, my lords.
Why they do?
Please,
There is a human aspect of it.
please. I bow down. I bow down.
If you are putting on them,
No, that will not.
it may not take much of a time for them to remove. There is a human aspect of it.
Please,
That
please.
that as a court, we are concerned with.
Please, I bow down. Please.
So that's the reason we are saying, so what is the best appropriate time? You will take instruction, tell us to us, then you will file periodical reports of the.
My lords, we will.
And within the time limit which we will fix it, you should ensure it is compliant.
Lords, we will. Lords, the funds have been released. It's in place. Everything is in place. Man, work has to commence. That's all.
You have taken after you have identified the place.
Well, conversions. We've obtained conversions, my lords. Conversions, plan approvals, all that we have obtained.
You have taken.
Yes. It's there in my affidavit.
The plans in operation.
My lords, tendering. I think tendering is a. Tendering may be necessary because it's a. 1 month. No. Because we cannot just give them a land, just cut it and give them. It has to be developed properly. It should be livable tomorrow. It's not possible. Please, that I do not have instructions, my lord. If my lord's direct, we will immediately implement. We bow down, my lord. We're in my lord's hands.
You have to give the timeline. We will not do anything.
My lord, within 1 year, our undertaking is that we will ensure that there will be no person inside the fort.
See, we have to preserve our history.
Please.
That's the intent.
Please.
So you will take instruction, what is the best period? Surely not 1 year. Come up with timelines. Say that this is the maximum period.
Please, phase wise. Please. Each goal post. Please, yes, please. 4 weeks time, my lords, please.
So for 4 weeks, you know.
No, my lord. Probably we will be able to place on record the progress made in the.
Positive is these people who are staying, they will have a permanent dwelling house for them.
Please.
You're getting the positive aspect of it, what you're doing.
Please.
That's the positive aspect.
My lord, please.
Just say that after the passing of the last
With my lord's kind permission.
on 16/4/25. 16/4/25.
With approvals.
Just say that we have heard Mr. Arvind Kamath, Archaeological Survey of India, Additional Advocate General of the state, and then the Additional Advocate General has drawn the affidavit filed by the Deputy Commissioner would be wherein in paragraph 32,
Vijay.
following has been stated.
ಇಬ್ರು ಕೊಟ್ಟಿದೆ ಇಬ್ರದ್ದು ಹಾಕಿದೆ
Following has been stated.
ಅಲ್ಲಲ್ಲ
ಇದೊಂದು ಹೇಳ್ಬಿಡಿ ಸರ್ ಲಾಸ್ಟ್ ನಾವು ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ ಅಂತ ಅದು ರೆಕಾರ್ಡ್ ಬಂದಿದೆ ಅಲ್ಲ ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಫೈಲ್ ಮಾಡಬೇಕಂತಿತ್ತು ಇದರಲ್ಲಿ ದಿಸ್ ಮೇ ಬಿ ನೋಟೆಡ್ ಡೌನ್ ದಟ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಂತ ಅವ್ರ ಶೀಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ ಬೇಕಾ
That the whole process may take 1 year. They also prayed for a grant of 1 year time for effective resolution of the issue. So during the course of hearing, it was put to the Advocate General, Additional Advocate General, that the period of 1 year is too large a period as the issue is in question, the preserving the archaeological site. So stop on this submission, the Advocate General has, Additional Advocate General has taken short time to take instructions that what shall be the appropriate time, which shall be less than 1 year for resolving the issue. So he also states he shall also give the timelines timelines for the, timelines to undertake the process from now onwards till the resolution of the issue. So the affidavit shall be filed within 3 weeks from today.
Please.
With a copy to the appearing for the officer.
Please. My lords, seek moment's indulgence, my lords. The report, my lords, an approval from the government for financial approval from the housing department. I just want to place it on record. Please, please. Please. Much obliged. Much obliged.
Your lordship, may I make a submission, my lordship?
Yes.
6-8, sir.
Serial number 62, my lordship. I could not log in on the right time. Some technical issue was there. List number 1, serial number 62.
Submission. Serial number 82. It was listed on 26 minutes. It is connected with the serial number 89 batch matters, common order matters. That day notice was ordered. Since I had requested this matter to be listed today, notice was not ordered. Can the notice may be ordered in that manner? Today it is there, 82 and 89. Serial number 82 is I am concerned. I have filed that appeal against the very same common order matters. It is arising under the EPFO scheme, paragraph 83 and 43. My learned friend, Mr.
I appear for the
BC Prabhakar takes notice for respondent number 1.
I appear for the respondent. I'm afraid to take the respondent.
Serial number 82 minutes. Date is not it. Respondent number 1 minutes.
1.
2 is EPFO. Madam will take
for appellants in 89.
EPFO. Yes.
Allah, 82. 82 lila. 82 lila ನೀವು. 82 lila. Please.
Yes. 23. Yeah.
There is no connected issue pending, connected to be
89 batch matters. It's a common order arising under 23 writ petitions.
So list along with.
Yes.
List along with the writ appeal number 187 of 24.
Yes.
Please.
Nine.
Notice on IS and main. Sorry.
9, sir.
9.
62, my lordship.
Number 90.
You want to mention a matter?
Yes, my lordship.
62, what is it?
I won't take too long.
62.
No, I don't know how much.
62. 6-8, madam. Madam, 6-8.
We have issued notice.
Your lordship, in that matter, interim application for stay is there, my lordship. So kindly a short date may be given.
Ma'am, we have issued notice on that.
Okay. There is an interim application for stay also.
All right, we will see it. Have they filed any contempt?
No, my lordship.
It's all right.
It's a company, a commercial appeal, my lordship.
Huh. Have they filed any execution?
No, they have taken temporary injunction against alienating the property, but so I have come on appeal against that order. Ex parte order has been given.
Just show us 62.
You go and file an application under 39(4).
Lordship, like,
You can file an application under 39(4) there.
as Your Lordship, section 13 of the Commercial Codes Act provides for appeal also, my Lordship. And she is not, the learned judge has issued notice only on IA number 2. She is not given an opportunity for IA number 1.
She has filed the suit. And what does this say? Who has filed the IAS before the court?
The IA has been filed by the wife of the ex-wife of the respondent number, sorry, the appellant number 1.
That's the other side has filed it.
Yes, my lord.
You are the defendant there.
Yes, my lord. I am the respondent there, petitioner, and she is the
Order
petitioner.
granted.
Yes, my lord. Ex parte.
Where is that? Which order? Which page?
Page number 37, my lord.
37. Where is the order?
My lordship, page number 37, my lordship.
Yes, where is the order?
37, lordship, the order is on page number 41, my lordship.
Where is the order restraining you?
Sir, lordship, page number 41
Where
of
is
the
the order?
petition, commercial appeal. It's my lordship.
Read the order which is restrains you. Read the order which restrains you.
Yes, lordship. Yes, page number 41, my lordship. Petitioner has filed IA number 1 under section 9 of the Arbitration Commercial Act, Order 39, Rule on 2, to grant expert perusal of records, which is notice that respondent 2 to 4 are making arrangements to alienate the suit chattel property, which are properties of the partnership firm. As such, the petitioner has made prima facie case for grant of ex parte temporary injunction. If ex parte order is not granted, then the respondents may alienate the suit chattel property.
You
Hence,
file
the
a
very purpose
39(4),
of
ma'am.
filing
How can
application
appeal
will be.
Why an
Lordship,
appeal
under
here? You
section-
filed a 39(4) there. And what is the date
Your
now?
lordship,
What is the
6/8.
date of hearing before the trial court?
It is on 2/8, my lordship.
2/8, file an application for 39(4) and get the matter resolved there. You have been given time
Your
to file
lordship,
reply to this IAS.
Your lordship, under section 13 of the Commercial Codes Act, the appeal is also maintainable, my lordship.
We will not entertain this appeal, ma'am. Then interim order, it a notice issued, you will file your reply, you will file 39(4), argue the matter.
If your lordship may see the order, she is not given an opportunity for IA number 1. She is given opportunity for IA number 2 only. The learned judge.
You
She
go and
says
tell the
issue
same before the
emergent
trial court.
notice on IA number 2.
Remedy is there. It is there. You can go there.
Okay.
Yes.
She
Better
has
would be you
issued
go
notice
there,
only
file an
on IA
application.
number. Oblige, my lordship.
Okay, we'll issue notice.
Oblige, my lordship.
You serve the other side.
Yes, my lordship. Oblige.
Now we have two parallel proceedings, one there, one here.
My lordship, that is on IA number 2, my lordship.
So which is your IA which you have challenged?
This, the appeal which I filed is IA number 1, my lordship.
That's right, under section 9. That's right, we have seen it.
She has filed
they have
IA number
restrained
1
the-
under section 9, read with. Yes.
Okay, issue notice.
The suit schedule property is not the firm much of it.
Okay. Let's give it in August, ma'am, after second. Yes, ma'am, come.
18-8, madam.
My lords.
You are appearing for whom?
My lords, I am
In which
appearing
appeal?
in WA 863, my lords. Mine is IA 5.
Now, IA 5 is for what, ma'am?
863. IA 5, my lords, I'm seeking impleadment. I'm a commuter. I'm a
But tell us
commuter.
one thing.
Now, my lords, many of the
No, we just wanted, now your would be the similar to what Mr. Chinnappa has argued?
to a large extent, I don't want to repeat, as a woman commuter, my lords, in fact, the reason why my pleading and therefore I want to therefore I want to continue, is that the order by the state government, the notification, one of the grounds, in fact, one of the main grounds for cancelling the scheme is that the scheme is considered as unsafe for women. That is, in fact, one of the reasonings. And as a commuter, I want to make some submissions, which I will wrap up quickly. Now, my lords, may just for a moment take out the 2 volumes of Writ Appeal 863, my lords. 2 or 3 main issues I want to point out. The core of my arguments, my lords, as a commuter, as an everyday commuter using bike taxis and using all other forms of public transport, is that bike taxis are not only the most affordable, most convenient, which also was argued, but also perhaps in the range of other public transportations like crowded buses and taxis, perhaps the most safest. And that too for women who are commuting for work. Now, the argument I'm making in my pleading, my lords, is that free, accessible, affordable, safe transport should be considered as part of right to life under 21 and also 19(1)(g), because it enables women to continue to work. Now, one of the issues, my lords may see volume 1 and 2. My lords, in fact, raised a question: which other states have similar rules and guidelines? And what perhaps was not highlighted. And in addition to what is produced, I also want to give 3 more. There are about 8 states, my lords, which have detailed aggregator guidelines, either specifically for bike taxis or generally which include bike taxis. And all of those have provisions which mandate safety and ease for commuters. My lords may just see some are provided in the writ appeal, some more I will submit, my lords. My lords may just for a moment see
Is
volume
the state
1.
taking a plea of safety of women? Or
Yes, yes, and I want to show that. Where the plea is taken for safety, my lords may just see page 366, which is in volume 2. This is of Writ Appeal 863, my lords, I'm relying on. Volume 2, page 366. The notification, this is notification dated 6/3/24. My lords may just see the second para. In the state of
for women.
It is also been observed, middle, that the law and order situation in the state is being affected and the scheme is considered unsafe for women. My lords, women, we are saying that we want the scheme. And in fact, this is perhaps the most safe. Were women or commuters asked this? Were they heard? And in fact, I want to submit data which shows that in all other states and countries where bike taxis are there, in fact, women prefer it.
What are the safety precautions they have suggested?
Safety, who, my lord?
The other states?
Yes. In fact, the other states have mandated several safety provisions. For example, the biggest safety requirement specifically for bike taxis is that drivers have pre-test surveillance. Yes, pre-eligibility requirements, that their background checks are done. Not only are their background checks done, there's police verification done of their records prior to giving them a license. And then there are other alarms, there are safety requirements, there are refresher courses. And in fact, my lords, the biggest safety requirement, I would say, in a crowded bus, I have no other provision to do anything if I am being subject to unsafe situations. In a taxi, where we see the maximum instances of sexual harassment, my lords, if there is a lock, I cannot come out. In a bike taxi, in fact, all those conditions are not there. My lords, West Bengal has even put timings. West Bengal has even limited bike taxi plying till a certain time in the night. So there are many safety measures that other states have put. In fact, I just want to take my lords through that. So all of those measures are there to enable safe access to transport for all persons, specifically women. And one more requirement, my lords, is that in many states, including here, there was an emphasis that even drivers are women.
Drivers are?
Are women. Drivers of bike taxis are women, and that is encouraged. So therefore, there is, in fact, even more safety. And if that is one of the criteria, my lords, in fact, all the other aggregator rules and guidelines, which I just wanted to point out, will actually show that it makes it a much more safer option for commuters. So, my lords, in volume 1, may I just, I will not elaborate, but just point out those measures. Page 226 onwards, my lords. I'll just take my lords through that. Page 226. This is of Chandigarh. This is of 2019 Chandigarh Transport Department issued an order where, my lords, in number 5, Roman 5, they include bike taxis will be predominantly included. Vehicles shall be fitted with the yellow number plate. At number 8.
Just 1 minute.
Yes, apologies.
Yes.
Yes. Then, my lords, may see 227 of the Chandigarh order, page 227, the last Roman 13. Page 227, Roman 13, character police verification of the driver must be done. So that was included in the Chandigarh order. Then, my lords, yes, where? Yes. Then this continues, page 229, my lords. Page 229, the continuation of the conditions at page number 9. Numeral 9, owner shall be responsible for ensuring safety of women and children passengers. This is specifically again for motorcycle taxis. Then, my lords, 230 is the Rajasthan bike taxi policy, specifically for bike taxis, page 230 onwards, wherein bike taxi policy of 2017 was introduced. And that, my lords, may look at the page 232 onwards, conditions, number 7. 232 onwards, conditions governing motorcycle bike taxi services. Let me refer to H onwards, my lords. H at page 233, various measures on safety and security of passengers will be enumerated from time to time by the Transport Department. Then J, antecedents of all appointed drivers shall be thoroughly checked by service provider, and a report of antecedents of drivers engaged shall be forwarded to the police station. So there is not just antecedents but police verification which is required. K, conduct of drivers towards passengers is mandated to be of a certain manner. Then carriage of minors is not allowed. Helmets, all of those safety measures are there. And then, my lords, on the next page, page 234, there are conditions put, my lords, from 8H onwards on fare, minimum fares, and not to be charged beyond a maximum fare as specified.
So what is that fare?
The fare the state will decide. But the fares, in fact, for bike taxis are lower.
No, that's right.
Yes. So therefore, it makes it far more economical for people to afford. It is far more affordable, and this maximum fare is also there, and that is fitted. And not just it is fitted, it is also displayed.
Yes.
Yes. Thereafter, my lords may see page 239.
We have seen. What do you say on the policy per se?
My lords, the policy, two submissions. One is that the policy is based on a study done, on a report done. The report which is submitted. The report which is done, the report, yes. The report which was done in 2019. The decision of the state government is based on this report. This entire report, my lords, while it says a 2019 report says that bike taxis are unproven. Their feasibility is unproven. So it was a report based on certain criteria that they followed. Commuters, women, if safety is an issue, were never seen as a group who were interacted with or whose feedback or consultation was taken. Thereafter, the very same report goes on to say that bike rental services should be allowed. And then, allegedly based on this report, the state government says there are law and order situations, there are also the safety for women. And safety for women is seen. Now, my lords, I want to in fact submit with my compilation, there are several other national reports by well-known organizations, in fact independent, not connected to any state government or the central government, which in fact review bike taxis and their safety, their feasibility, their affordability, and in fact recommend that bike taxi as a... So on what is this policy?
Law and order, no, it's not unsafe for women.
It is in fact more safe for women, and it is more affordable. And in fact, the other reports, in fact, show that. We are not stating, my lords, on can we say that all reports will vary so blatantly. When there are there are other research organizations, well-known consultants and their reports like KPMG, there is a KPMG report, and all of those show that bike taxis is not only the most viable form, but it is the most safest and convenient and affordable form for commuters. That is what we want to show.
But how would you say affordable when the rates have not been fixed?
I know it's rates, therefore the policies will have to fix the rate. Rates will have to be fixed. Rates, in fact, as per all the state policies, maximum rates or per kilometer rates should be fixed. Therefore, it would then become in fact, when it was plying, it was the most affordable. And those rates, in fact, all the rules mandate that those rates are fixed. And that's why I wanted to just show that to my lords. Now, my lords, to quickly go into that, my lords, at page 239 is the Bihar.
This is fine.
Where?
This is fine. Every state maybe largely would be a common, policies.
Yes, but the common policies, my lords, in volume 2, there is also Jharkhand and West Bengal. But may I just show, my lords, in the compilation that I have handed over, which is not on record. Yes. If my lords can just see the compilation that I have handed over. My lords, at page 2 is Meghalaya, which is a 2020 regulation, which also includes motorcycles or bike taxis. And my lords may see at page 7. At page 7, page 7 of the Meghalaya guidelines, driver profile is there at the bottom of the page.
Yes.
Driver profile, B4 says without any criminal record, no convictions for past 7 years, and so that is the antecedents of the driver. And on the next page, my lords may see 6. Licensee shall endeavor to have women drivers. So that is to increase commuting by women with women drivers.
That's fine.
Yes.
Yes.
Yes. Page 9, my lords. My lords, the reason I'm pointing these out is that these conditions are far more stringent for bike taxis in order to address the safety concern. And therefore, these additional concerns are put. Page 9.
Fine.
Yes. Then, my lords, the only other there, I have produced Meghalaya, Assam, and Goa. But the only, I would take the liberty to.
How many
There
states
are
have this scheme?
my lords, I have produced 8 states with the scheme.
How many?
8. 8 states have the scheme. Now, my lords, the total number of states, in fact, I will just show there is a report by KPMG. My lords may just for a moment see the report at page 66. And
What is the basis for them to give a report?
I'm sorry?
What is the basis of that report?
No, they have done their study. They have done a national study on the feasibility and the requirement of bike taxis. They have done a national study. What they state in their national study, my lords, is that at page 89 of the KPMG report, at page 89 of the compilation,
Yes.
page 89 in of the compilation, my lords, page 89, they in fact highlight for commuters, bike taxis are the most affordable, pricing can be transparent, convenience, quicker time, and safety. And the number of states they list is at page 95.
They say it's safe.
Yes. In fact, the way they say it's safe is that is, my lords, at page 113. At page 113, all the safety measures provided, whether it is SOS tools, that is any alarm, helmets, driver verification. In fact, there is a chart. Late night checks. Many places there are late night timelines, insurance, complaint mechanisms. And in fact, they show the last para of that page, my lords, at page 113. Platform-driven bike taxis offer a significantly higher degree of safety while commuting for a rider.
But that
Then,
never happens.
in fact, my lords, the data shows that they are safer than other modes of transport. In fact, I want to rely on some academic pieces. My lords may just see at page 125. In fact, before we get there, just closing the KPMG report at page 95. There is a list of all the bike taxi operations in different states. My lords asked me that question at page 95.
Yes.
While rules are there for 8 states, At page 95, the status of each state.
So tell us, when a woman driver is there, then the male sits will not be an issue.
My lords, in fact,
Precautions there.
my lords, in fact, for women commuters, and as a
We are asking a different one.
The reverse of it.
Reverse of it.
where there is a woman driver,
That's right.
yes,
A woman, she is a bike taxi driver, according to.
where there is of course, in India or in
Option not
Karnataka.
in our apps where the drivers can say, women drivers can choose only women passengers.
No, but my lords are asking the opposite.
But,
My lords
when-
are asking opposite.
When she comes to the spot, then only she will come to know that this.
In fact,
computer should be a male.
drivers and passengers can choose.
She can
Drivers
choose.
and passengers can refuse.
As well as the passengers.
Yes. Drivers and passengers can choose. So a woman driver, of course, it's not extended to that extent, but in many other countries like Philippines, etc., where there are huge.
Let's not bring something.
Other
happening
countries-
No,
outside to our-
the only the
Yeah.
example where there is a woman driver, she can refuse a male passenger if she doesn't want to take.
American conditions, European conditions will
Certainly.
not be in India.
Certainly,
and
we are
that
not.
Cannot be a model.
No, it is not a model, but it is only where similar situations are there. In fact, my lords asked a question, what if there is a woman driver? And what about her safety? My lord, she can refuse. She can choose only a female passenger to ensure that there's safety. And all those mechanisms are provided in many rules, and those can be implemented. In fact, that is one of the
Okay.
criteria. Yes.
Very good.
Now, my lords, may I just,
Do one thing, ma'am, just give your submissions also.
I'll give my submissions.
Broadly, you have said, ultimately, this, the policy which contemplates the woman being unsafe, or this taxi, this whole scheme is unsafe for women.
It's not.
Is not sustainable.
Is not at all sustainable. In fact, it's far safer. Our threefold submissions are affordability and convenience and safety for women makes it the best affordable option for women. And my lords, the last, though my lord said not to compare, one article where in fact the Indian situation was taken into account is at page 125. I'll leave that for my lords. At page 125, where in fact even women passengers and the experience from India was also taken into account for safety. The existing bike taxi use was there, and the perception of safety was in fact raised at page 132, including India.
Is there any survey done
In fact, my lords,
of women in the country where they have been asked whether they would be comfortable?
that is exactly the perception that women say. My lords, kindly see page 132.
It is of Manila.
No, this includes India. I will show my lords. This, though the title may be Manila, it includes India.
That would be one of the real tests.
That is the test. In fact, kindly see at page 132. Even the KPMG one states that, but I will point out. At page 132, just under the graph, may I read out? Yeah, now I'll finish it.
Yes.
Perception of safety, 132 consistently. In fact, the previous page, 131, perception of safety, my lords asked me that question. And this includes India, and I will show that, my lords. When asked whether they feel comfortable riding the MC taxi, which is motorcycle taxi, 72% respondents answered in the affirmative. For those who stated they were not comfortable, the top causes of discomfort were using a helmet, holding the driver, etc. And on the next page, consistently, 69% of respondents do not feel unsafe riding the MC taxi as a woman. For those who replied otherwise, top reasons for feeling unsafe were involvement in road accidents. So it was not on the issue of the taxi. And this, in fact, my lords, this article includes. Yes. So for that also, the driver antecedents, police verification, all of that is done. So I'll give my written arguments. My lords, I've also produced data on how the traffic has in fact increased after the 16th June ban. And those articles and the data is also produced. Yes, yes. So therefore, my lords, my submission is that from a commuter perspective, these criteria are extremely important. And none of these have been considered by the state in that policy or in their notification, where in fact safety of women or ease of commuters is even taken into account.
Thank you.
Grateful.
Yes, Mr. Ola.
I mean 91 word aggregator, yeah, the appellants.
Yes.
Lord, we are filing, Lord, one, sorry, too many compilations. Lord, why we had to file this was, I'll tell your lordships. One argument was canvassed saying that, my lord, the yellow bikes are, taxis are not available. We have produced, my lord, the photographs. Please have a look at, my lord, this. Apart from the aggregator rules, physically, my lord, they are there. If your lordships come to, my lord, page 9, 9 to 20 are all, my lord, Rajasthan bikes, rental bikes, bike taxis, 9 to 20. Then, my lord, 21 to 28, West Bengal, my lord, WB.
These are specifically for the
Bike taxis. Yes, and then next, Bihar, 29-31. 21 to 31, BR. Madhya Pradesh, 32 and 32 to 34. MP.
Yes.
Then, my lords may come to Uttarakhand, 35 to 47.
We have seen that.
Lord, any number of all the states have, my lord, this. Even Tamil Nadu, my lord, though KPMG report says Tamil Nadu it was initially banned, they have now permitted. Tamil Nadu has permitted, and Kerala also has permitted. Three southern states had not permitted. My lord, that's what the KPMG. Maharashtra also has permitted. Then, my lord, would your lordship look at another aspect? Please come to, my lord, the first page. Sorry, page 8. Look at the metro. Where does the metro lines go? And, my lord, what is the spread of Bangalore? Metro lines are only 2, my lord. In fact, there's no last mile connectivity even when there's a metro. In Malleshwaram, my lord, it goes to, my lord, Sampiga Road, that is third cross. People, my lord, in other places, my lord, they just don't, my lord, have anything. And, my lord, only 2 lines. In fact, my lord, all, my lord, places like Japan or Tokyo or, my lord, US, there are, my lord, so many multiple lines.
They are coming up. They are coming up.
Not here, my lord.
No, in another.
Even if it is so, my lord, it will be, my lord, my lord, please look at the spread of Bangalore. Spread of Bangalore, my lord, it will not cater at all. That's all that I'm saying. And there is a need, my lord, for taxis. In fact, my lord, please come to, my lord, the latest, there is an order passed by the central government itself. Please come to running page in 61, my lord. Central government has come up with this from 1st of July 2025, the motor vehicle aggregator, my lord, guidelines. In fact, this, my lord, it's an improved version of the earlier one, and they are saying, my lord, as your lordship sees in para 3 of page 61. Sorry, para 2. In 2020, Ministry of Road Transport Highways issued motor vehicle aggregator guidelines under section 93 of the Motor Vehicles Act. The said guidelines provide for regulatory framework for the state governments to issue licenses and regulate aggregators in the road transport sector. Now the motor vehicle aggregator guidelines 2020 have been revised to keep the regulator framework up to date with the developments in the motor vehicles aggregator ecosystem. New guidelines, that is motor vehicles aggregator guidelines 2025, attempt to provide a light touch to the regulatory system while attending to issues of safety, security, etc. And, my lord, please come to, my lord, page 88. The Vahana, my lord, is a page 88. This is, my lord, the website of, my lord, the Department of Ministry of Road Transport. 3-wheelers, my lord, please have a look at it. This is the numbers. And 91, if your lords come to. Motorcycles, my lord, is there, my lord, Vahan says, serial number 6, my lord, motorcycle scooters used for hire. 1,34,896 across the country, my lord. So it is not as if then they rely upon, my lord, one report to, my lord, deny this. Who is, my lord, made the report? Only, my lord, the chairman of Metro. Nobody else is there. One man report by, my lord, the erstwhile chairman of Metro Rail Corporation. Then they are speaking of, my lord, the learned single judge has spoken about, my lord, policy. Please look at their objection statement. Not a whisper, my lord, by the state has filed its objection statement. If your lordships take, my lord, our petition or, my lord, any petition to the objections to the writ petition, 948 idea nimatra.
It commences at page 322.
Volume 2 togoli.
Page 322.
322, my lord, if your lordships come to. This is the objection statement filed by the state. My lord, in the entire, my lord, objection statement, I have gone through it myself. Not a whisper that there is a policy, and, my lord, this is contrary to the policy. Therefore, my lord, we are now learned single judge, my lord, if your lordship look at his order, he, my lord, says there is a policy, and therefore, my lord, he can't. My lord, I'll just point out. If your lordship look at, my lord, paragraph, the first volume, my lord, is the order. Page 35, my lord, of the first volume. It starts. Please come to my lord, page 81. Paragraph 12.9. Therefore, the state government cannot succeed either on the ground of definition of motorcycle. My lord, he comes to the conclusion, my lord, that motorcycles, my lord, are permitted. They are contract carriages. I leave it at that. But with regard to the policy, the 1 minute, I had noted it. I see. Correct. Yes, my lord. Issuance of, my lord, the page 89, my lord. First paragraph itself, my lord. No, not 89.
Or come to paragraph 15, page 95.
Correct. That's what it is. 15.1, my lord. MV Act has invested jurisdiction in the state to frame guidelines. Therefore, my lord, they have framed the guidelines. There is a policy. State has taken a policy decision. That's, my lord, last 3 lines from the bottom. My submission to your lordships is 3 things, my lord, have to, my lord, your lords may bear in mind. One is the division bench order, my lord, passed by the, my lord, Mr. Chinnappa has already said, I don't want to repeat myself. Paragraph 12 to 14, my lord, the notification is referred to in that division bench judgment. And, my lord, they have specifically held, my lord, that bike taxis, my lord, were permitted. My lord, in fact, 2 things, my lord, I want to place before your lordships. Division bench, my lord, specifically held that, my lord, bike taxi guidelines are to promote, my lord, urban mobility. If that is so, my lord, if all across the country, bike taxis, my lord, are provided, because, my lord, it's an urgent requirement. My submission is, my lord, please look at Bangalore itself, my lord. If your lordships, my lord, there were times when I came, my lord, as a small child of, say, 10 years, from one end to the other end was, my lord, in the peak hour was 20 minutes. From one end of Bangalore to the other end. Today, it takes, my lord, 3 to 4 hours. It is in this scenario, my lord, what happens, my lord, to the commuter or, my lord, a passenger who wants, my lord, go a little early? 3 hours, 4 hours, my lord, if he spends, my lord, on transport or, my lord, to reach his, from his office to the house or from the house to the office. My lord, his entire time is spent on that. He can't, my lord, spend time with his family nor, my lord, in the work. Therefore, my lord, bike taxis, my lord, are an essential requirement in a urban setup, would be our submission before your lordships. And therefore, my lord, the aggregators, my lord, assist this in this manner. And, my lord, there are aggregator rules. Then, my lord, as far as the safety of the women are concerned, my lord, I ask myself, bike rider, the woman, my lord, sitting at the back, or, my lord, lady bike driver, man, my lord, sitting at the back. What happens, my lord, in a taxi? Same thing. If a driver, my lord, is the lady driver in the front, passenger, my lord, sits at the back. Same thing can happen. Therefore, this, my lord, bogey of women's safety, my lord, apart from what, my lord, Ms. Jaina Kothari has already argued, would be, my lord, is a misnomer, and, my lord, it's just put forward, my lord, to ensure that, my lord, bike taxis are not, are avoided. All this is because, my lord, there is a strong, my lord, auto drivers association, and, my lord, they are, my lord, coming in the way. Therefore, my lord, my submission to your lordships is, this is the scenario under which, my lord, this bike taxis, my lord, have been banned here, my lord, in Karnataka. My submission to your lordships is, one, they cannot deny, my lord, where does the power of the central government and the state government lie? Only, my lord, with regard to the aggregator rules. As far as bike riders are concerned, Lord, they can't refuse the registration. It is only against the aggregator that, my lord, rules can be made. Your lordships have seen, my lord, I don't want to, my lord, repeat myself. Section, my lord, itself specifies, as far as the aggregator is concerned, state has the, my lord, power to frame the guidelines. Not in respect of, my lord, the bike riders, whether, my lord, they can be given license or not. That, my lord, is mandatory. If that is so, my lord, aggregators, my lord, assist the commuters. In fact, I can tell your lordships, today, everybody, my lord, goes to Uber, my lord, for a taxi. If, my lord, we don't have our vehicle, We can't, my lord, get a taxi, my lord, just like that. We, my lord, get into Uber, my lord, they'll have, my lord, they'll be able to, my lord, the aggregator will be able to, my lord, search for that taxi and, my lord, give us a taxi, my lord, in a matter of minutes. Therefore, my lord, aggregator assists. But bike taxis, my lord, if they cannot be, my lord, individual drivers, they, my lord, cannot be prevented by the state. My lord, aggregator only facilitates, and therefore, my lord, the state must, my lord, come forward and, my lord, change its guideline would be my submission. My lord, more than that, I don't want to say because Chinnappa has already argued. Alva?
We will continue, Mr. Raghavan.
ಇನ್ನೊಂದು ಲಾಸ್ಟ್ ಇದು ಇತ್ತಲ್ಲ ಬೇಕಾದ್ರು ನಾವೆಲ್ಲ ತೋರಿಸಿದ್ವಲ್ಲ. Can we continue
With
tomorrow?
leave of the courts, my lord.
Yes.
Please, my lord.
Correct. ಇಲ್ಲ ಒಂದು ನಿಮಿಷ.
But do not take more than half an hour, we will not
We'll
take.
have it next Tuesday, Mr. Raghavan, not before.
We will not take more than 20-25 minutes.
ಇಲ್ಲ ಒಂದು ನಿಮಿಷ.
So tomorrow, Mr. Raghavan, I accommodate this, Mr. Raghavan.
This, that's the old ones.
We have matter, Mr. Raghavan.
Or day after, Mr. Raghavan.
ಎಲ್ಲಿ ಮಾಡ್ತಾರೆ ಇವರು ಇಯರ್ ಮಾಡೋದು ಆಗೋದಿಲ್ಲ ಮಾಡೋದಿಲ್ಲ.
Take a chance on Friday.
We'll do that. Great, we'll do that.
My lord, two more submissions, only 2 sentences. If your lordship take, my lord, what compilation I have given. After the bike ride, my lord, was stopped, 18%, my lord, hike in the traffic, my lord. Please look at, my lord, page 56. Traffic congestion, it increased by 18%. Page 56 of, my lord, the compilation act.
That increase happened.
My lord, because bike taxis, my lord, are not there. Therefore, my lord, people will have to, my lord, bring their car. Yes. 18%, my lord, increase.
How many taxis have gone off the road?
My lord, nearly about 1 lakh and 6 lakh across the state, 6 lakhs, my lord. And
Yes, second point.
second is, my lord, the auto rickshaw, state itself says there is a need to, my lord, increase it to 2,55,000. That, my lord, also we have kept it at page 18. I'll give a note.
This is their statistics.
My lord, their own notification, my lord.
Wow, latest.
Yes. My lord, in a 5-year period, we will increase it to 2,55,000. My lord, 2024, this is a notification. This is, my lord, I'll put a note and then give it to your lordship, my lord. I know your lordship is so kind and considerate, giving so much of time to every one of us.
Thank you.
Grateful.
One thing is bike taxi has not gone off the road. Those bikes remain, but they're not operated as bike taxis.
They are using the.
But they're using it for themselves. Which means not there are additional vehicles coming on the road because others who use bike taxis are now using their own vehicles.
But what is it? Are they not using their own vehicles, Mr.
Some of them don't,
No,
because we use, if there is bike taxi available, you'll use a bike taxi to commute. If there's no bike taxi, I have to take out my bike.
But once,
Which means you double the
Uber, Ola
vehicles.
came into the picture, people stopped buying
Then
cars.
the numbers
Once
will be
Uber, Ola
double.
came, because it was more comfortable, not to, rather than have a driver or find parking in Bangalore, not to book a Uber or Ola cab.
So now, is it happening in Bangalore? Possibly, my observation.
Yes, my lord, it is. I can only submit this. London, you can't, my lord, have your taxi, your own car because there's no parking possible. Therefore, my lord, everybody uses Uber. And this is, my lord, this is what is happening today, my lord, in Bangalore also.
If it doesn't rain, people take out their car. If it rains, no, if it doesn't rain, they take their two-wheelers.
Yes.
If it rains, possibly cars.
But in the past 2 weeks, my lord, it hasn't really rained. But we will see that effect on the road in the sense that, my lord, the traffic has gone significantly.
But yesterday, before yesterday, the traffic is more.
Even today, my lord, getting to court today.
Must be, it was Tuesday. Okay, thank you.
Thank you.
Serial number.
You're filing?
I have filed it already in the counter, my lord, so far as my response to be had.
Yeah.
That is filed in the
What
counter.
is this?
This is just the summary of submission.
Give it.
Serial number.
We'll take a matter for.
I'm sorry, my lord. Would it be 230, my lord?
I will take it after 2:30.
It'll come in the regular list.
It could be mentioned as 2:30.
Very great.
My lords.
Serial number 87. Serial number 87. Date will be fixed.
Here, 87, just see the date, man.
Lord, serial number 81, there is a IA for condonation of delay.
My lords.
Next day.
Serial.
This may be ordered, that's all.
We are not getting up. We are just here. Give us 5 minutes. We have to hear it. You just give the dates to. Yes.
Please, Lord.
Now tell us who is there from the other side.
The Advocate General, Additional Advocate General means.
Where is he?
She was there. Means. She was there. So for the court convenience minute, I have filed a counter affidavit on
Now just
24th.
tell us what should be the proceedings today.
Date has to be, I mean, it cannot be just, they had to file a detailed affidavit, what act
200 meters, there is a government school and a residential area, my lord. The schools have restarted, my lord. There is an urgency, short date, my lord.
So we'll adjourn it, we'll have to give a date.
Yes, my lord. Short date may be given, my lord.
What is the urgency, ma'am?
Because schools have already started, my lord. The students. Within 100 meters, there is a government school, my lord.
You are appearing for whom?
Petitioner, my lord.
School authorities?
No, my lord. I'm the one of the residential in that area. A short date may be, and notice may be issued, my lord. Notice may be issued.
Which number is this?
76. 76, my lord.
We will have it next week, maybe we'll see. Next.
10/7.
So what is the date? Just give a date, normal date.
My lordship, serial number.
87.
My lordship.
Okay.
My lordship, serial number 57, execution date is this month, 26th, my lordship. Before that, any date maybe. Serial number 57.
Date there in execution, you file an appeal. Just give a normal date. We'll get up.
For transmit. 93.
The respondent wants. Pay for the respondent.
The commercial appeal 181 of 2025 is allowed. The impugned order rejecting the plaintiff set aside. Commercial appeal crop 3 of 2025 is dismissed. Consequently, IA number 4 before the commercial court stands dismissed and the suit is restored to the file of the commercial court and it shall proceed in accordance with law. All interim applications, if any, stand disposed of. Costs made easy.
Madam.